outside the city location. Second half. Stated lot.
41. Have it on 2nd April.
Or complex.
The request made by Mr. P. Sharma. Expressing personal difficulties. Just again. End of April as agreed by the parties for the council. By the council for the party. 40.
Sir, with the consent of the petitioner's counsel, I make mention item number 38, hearing, some difficulty on my part today, we have given consent, otherwise, if date may be fixed after due, on 28 or 30.
38 on the request made by the learned CGC, Mr. P.K. Parathar, matter stand. 3 weeks. Let it come, it's a hearing matter, let it come in the part 2 hearing list of May. May.
Okay. When I beg to mention a disciplinary petition Monday, yesterday I filed this petition regarding the dismissal of the doubt one. Come up on Monday.
You mentioned it on Friday. After the filing is over.
No, filing is over.
Numbers are given.
Yes, filing number is there.
All right. Monday. Yes.
Please, your lordship, I beg to mention WPC lordship.
For what purpose?
Admission.
Admission matters. We have to come after the petition. 27th April.
Wait, please, your lordship. Lordship, I beg to mention an urgent listing of a writ petition. It was filed last year, lordship. Lordship, the issue
Last year.
Yeah, 2025, 3291. The pleadings are complete. The issue here is, lordship, there is a stay operating in my favor where I had challenged an advertisement for the post of DGM marketing. So, lordship, what has happened to circumvent this advertisement? They are now internally allocating this post to someone from. They are bypassing this advertisement completely, and they are allocating it to someone internally. And the interview for that is scheduled tomorrow, your lordship.
When do you want the listing?
Lordship, may tomorrow or Monday, your lordship. So at least we can stop the recruitment thereafter.
Let it be on 1st.
First, your lordship, a little bit earlier if we can.
So a little bit earlier would be 30 on Monday, but Monday we are already overboard.
First, your lordship. First. Much obliged.
I beg to mention item 4, my lord, some instructions were required regarding retrospective. My lord, may I pray for some accommodation, my lord?
Who's for the respondent? The petitioner. Any objections?
No, my lord.
Item 4 on the request made by Mr. I. Thakur, Standing Council, Forest. Matter stands deferred. We listed in the first week of May. First week of May, date to be fixed by the registry.
I find out a deputy declaration.
That's the reason why it is for orders.
Yes, sir.
It will be pulled up. Not to make a mention then.
May I please ask? Well, item number 30, my lord. This matter has become infractious. 30, my lord.
Item 30
Yes, ma'am.
on the submissions made by Mr. T. Sheikh, Learned Council. Hearing for the
Please, lordship. With the concern of the petitioner, sir, I beg to mention item 31. I'm appearing on behalf of SC, Mr. PJ. Due to some personal difficulty, I humbly pray that the matter may be taken.
Have you informed the petitioner's
Yes.
counsel? Item 31 to be listed after 4 weeks on the request made by standing counsel on behalf of standing counsel.
Application, Lordship, I beg to mention for withdrawal, Lordship. WBC number 1416.
Tomorrow,
Similar prayer, Lordship, WBC number 1.
for withdrawal. Tomorrow.
Three cases, WPC 22 cases. They were last posted on 6 to 25. They are all related to seniority matter. They are employees of a Good Corporation of India. This was taken with another case in which they had challenged the employment order of the disciplinary proceedings against them. Those cases have been decided in favor of the persons for which I. So once they are decided, they are decided by the in bench. Now they can be proceeded with.
You are saying that some other writ petition or appeals have been disposed of, where the issues are similar, and your writ petition stands covered with that order.
This is seniority matter, but the disciplinary proceedings, what were initiated against them, those have been given out of favor. So now this can be heard because it was kept in abeyance because of that verdict.
When do you want the list matter to be listed?
If you please 6/4/26 or 33, whatever.
33 is not possible.
26/4 is it possible?
26/4. 26/4 is a Sunday.
It may be 27th.
27. 27/4.
Obliged you.
I beg to mention two admission matter related to family culture on past people.
First. After vacation. 24th or 27th? 27. April.
There are lots of 16 to 21. 16 to 21. Come adjournment effect.
Why?
Lordship, myself also, I have to be fixed. The advocate general is appearing in this case.
16 to 21 on the request made by Standing Counsel AFDC, that is led by the Advocate General of the state. And he seeks an accommodation stands deferred to be listed after 4 weeks.
On 7th, madam.
No fixed date. So seeking an adjournment, we are fixing matters for what purpose? For adjournments?
Then, madam, 2 weeks, madam.
No, 3 weeks, 4 weeks. 2 weeks, 2 weeks, there's a holiday. So it comes in the end of the month or beginning of next month on a date to be fixed by the registry.
Comply.
Obliged.
Third to item number 9 to 14. I request some time note. I've taken the consent note. 9 to 14 and supplementary, there is one motion.
What instructions you want?
Lordship,
What are these matters?
These are the NCL certificate validity
Then
of the
what
NCL.
we have been issuing notices and they're lying here for what purpose?
Lordship, there was a notification of the year 2017 that when the last occasion court has asked whether this notification will cover the 180 days period. I have received the instruction from the SSC, it will cover, but the federal officers, they are yet to receive that. Lordship, so I'm saying, because their rejection was from BS, some of them are from BSF and some of them are from CRPF.
So if
That's
you have received instructions from the
Then-
authority concerned, they are bound to follow. Nodal
That's
officers are
bound
bound to
for-
follow.
But there must be a originum has to be issued that because it's of 2017. That's something.
No, you allow the matters to be called up.
Lordship,
Not proper like this.
Lordship.
Even adjournment without. And if the authorities have agreed that it covers,
Lordship.
something is to be done, then if any orders are required, we'll issue orders.
That's corrigendum is to be issued from our side, Lordship, that's all.
So we close this matter, giving you liberty to issue
Let
corrigendum.
it be after, immediately after the vacation. In the meantime, Lordship. that
We are
will-
closing these matters, giving you on recording your submission that corrigendums are required to be issued. Give you some time, 3 weeks, 4 weeks, whatever time, you issue corrigendum and complete the proceeding.
Instruction is immediately after the. Immediately after.
On what grounds? On what grounds? Tell us.
That-
On one
Lordship-
end, you are saying corrigendum is to be issued.
Lordship, because of Lordship.
You
that-
wait, let the matter be called up.
Lordship.
Wait for some time.
Lordship.
Yes.
May I please order? This matter pertains to condonation of the authorized. Last of the personnel department was directed to take the inspection.
Yes, in the instructions.
My lord, my lord. I have received inspection in both the matters, my lord. From the inspection. My lord, here the issue in the first case, Dr. Sanjay Kumar, the instruction stipulates that, my lord, initially in the year 2024, he was given a relaxation. My lord, he sat for the exam and he could not, my lord, get through the exam. So now, again, he has submitted, my lord, and now his age will be again 52 years, 11 months and 17 days. So he is overaged by 1 year, 11 months, 17 days. In my lord, this para 7, para 5, my lord, there is clause 5 of the letter. It states that as he has already availed relaxation and failed departmental examination in 2024, further relaxation was not considered and hence the proposal was rejected. That is the, my lord, since once we have already given it, he could not, my lord, succeed in the exam. So a second relaxation cannot be given for both the petitioners.
Lord, I'm not denying that earlier relaxation was not given. When I have submitted, placed the record also at page 40, that relaxation was given. But my submission is that, my lord, so the department has introduced a new subject, that is commercial bookkeeping, which was the petitioner is a science background student, so he needs some time to go for the subject. Therefore, he couldn't succeed in that subject. Otherwise, he has flourished in all the other subjects. So,
Is there any rule or anything that relaxation has to be given only once?
My lord, there is no precedent that we have given twice. There is, I asked, they could not.
but if you
What does the rule say? What, there any set of rules or notifications? What notification was there?
regarding Rule 27 of the Assam Finance Service Rule, my lord. So, basically, by citing the Rule 27, they have earlier also relaxed, my lord.
Basically, my lord, the discretion of the department, my lord.
I'm not denying that it's not the discretion of the department. Definitely, it's the discretion. I'm just praying, my lord, that, my lord, I have been appointed in 2001. Then I was promoted in 2019, my lord, after 18 years of service.
Because, my lord, giving such relaxation more than once.
And they are not
Open up
frequent,
Pandora's box. Everybody will come, my lord.
and they are not.
That becomes the difficult part. In the, my lord,
Under what rule? Under what rule?
My lord, Rule 27, my lord.
Rule 27.
It's a general rule, my lord, basic.
Where is the where is that relaxation? I mean, where is the age limit?
My lord, age limit is at Rule 5, my lord. Five.
You are seeking a promotion to the post of
Post of FAO, my lord. Finance accounts.
you are now posted
As deputy accounts officer. Sorry, my lord. They're promoted to accounts officer now as accounts officer.
became eligible in which year?
My lord, in 2019, my lord.
19. You became eligible for promotion after completing the departmental examination, etc.
Yes.
Then there was a relaxation given to you.
Oh, my lord. Sorry, my lord. I was eligible in 2024 only because I have been promoted in 2019. So it needs 5 years in that service, my lord. So then 24, I was eligible, my lord.
But you failed to clear.
Yes, my lord.
After relaxation, he paid.
But they have introduced a new subject. I have already submitted, my lord. So in the entry cadre, there was only means only any graduate can be entered, my lord.
How many candidates are here now?
It's not more than 15, my lord.
How many vacancies?
Vacancies is at it's 12 vacancies, my lord. At page 31. Advertisement.
What is your age now?
Now 52 years, 8 months.
52 years. 11
Sorry, my lord, 52 years,
years,
11 months, 17 days.
17. Altogether 12 posts in 3 different categories. In account service, my lord, it is 5.
How many candidates are there?
That my
How many candidates?
that look, I will have-
Page number 46.
Yes, my lord. Earlier also they have relaxed for 2 years, 11 months.
Here
They had relaxed in your case, but now you're asking relaxation for the second time.
second time.
My lord, yes.
Whether, my lord, the question here is whether a second relaxation can be given to a candidate only on the ground that he could not prepare his exam. He failed. Is it a valid ground? Because on the last occasion, what my friend is, my lord, his grievance is that there are the new subject bookkeeping. It was for all, my lord, not only for him.
Now,
Everybody appeared for that.
For this
So
promotion,
except one, everyone was failed in that subject, my lord. Except one who was the commerce background, so he could only succeed. Otherwise, all are in that subject.
now what is the this the only avenue for promotion or there are other
That I don't know, madam, that finance department can manage.
finance? Who's for finance? What we want, supposing this person has failed to secure, clear the departmental examination, thereby he is overreached. We have no claim for promotion ever.
Madam, I am not aware, I cannot, finance, madam, just,
Yes, Mr. Counsel.
That I need to take into account.
I don't know, some finance department. One also.
Lord, he was appointed in 2001. Then in the year 2019, after 18 years, he was promoted to the deputy accounts officer. Then 2023 accounts officer. So 2000, then 24, he is eligible for this departmental promotion examination. So had he been earlier promoted, then definitely he could have applied in 2018 exam also, because they have not frequently conducting that examination, departmental exam. As rule says that every year there should be an assessment for the vacancy for departmental promotion examination. Not in Rule 11, so it was specifically written that before the end of each year, the appointing authority shall make an assessment of number of vacancies occurred or likely to occur for filling up the promotion in the next year in each cadre. So it's recruitment by promotion through the board.
Get the instructions whether what are the further avenues of promotion.
My lord,
Examine and see.
that may take up after some time. I will take them.
Mr. Gogoi, the question is that he failed to clear the departmental examination. Now, assuming he's not entitled to sit for a second examination because of his age barrier. Now, what happens to his promotional avenue? under the rules.
That,
Take your instructions and tell us.
let it be. That instruction, but I will have to. write it down.
On first
What?
of April.
That I can write.
Matter be listed on 1st of April, enabling council to start instruction as to the sources of avenues for promotion for persons similarly situated like the expedition who had failed to clear the departmental examination and is not permitted to reappear because of the age. Instructions will place into the court. Staying list on first. Huh? Mr. Art Hall, government counsel appearing to the personal department has placed before the court the views of the personal department as to the prayer for rejection, as to the rejection of the prayer of the condonation of age limit for the writ petitioner, which was conveyed to the finance department. That's it. Mr. P. Dottovo. For it.
Much of it.
Second about what? Huh? Second of Matile no, second about Martin to council. Counsel for the petitioner submits, like to file the reply. The counter affidavit filed by the respondent. Prays for 2 weeks time.
Obliged.
After 2 weeks, Mr. R. Hall for the respondent.
Obliged.
Respondent has not filed any affidavit.
My lord, we are yet to file the affidavit, my lord. Ready, my lord, should come. We need some.
Mr. R. Hall, State Council submits that the affidavit is available to him and will be filed in the course of the week.
Next week.
Within 1 week.
Let it come after vacation.
After 3 weeks, counsel for petitioner is permitted to file rejoinder affidavit to the proposed affidavit, counter affidavit to be filed by the respondents. In the meantime, Mr. R. Sinha for respondent.
Them a lot without their salaries from almost for the last 6 years. But on the last occasion, each Chakraborty appeared. That she will yes, she was to not from the record she was to show whether the petition on the subsequent petition case final. She was to show whether these notices of termination were served on us.
Where are the notices of termination?
No, these are not with us. We never received them. That's a stand taken, my lord, by the petitioners that respondents that we were terminated.
When?
But my lord, in November and my lord 23 and my lord, 1 in January 2023. My lord, but as far as our case is concerned, my lord, we never received any such my lord, intimation regarding termination. And these kind of orders were never served on us. So only by an affidavit that my lord, they told us that we have been my lord, terminated. This is an affidavit filed my lord, in the earlier retribution, my lord. Lordship will find my lord, that page. In the earlier retribution, my lord, 4997/2020, my lord, the state filed an affidavit, the department rather, filed an affidavit, my lord, saying that our services were terminated.
their stand was the petition number 2 to 4 were discontinued, my lord, from my lord 1/11/1/3/123.
Which
And-
affidavit?
My lord, affidavit of the respondent, my lord, in my lord, WBC number 4779 of 2020, my lord.
4779 or 4997?
4997, my lord. That is an affidavit.
Filed on?
I'm just kidding. That was filed on, my lord. 11/3/2025, my lord.
Paragraph?
11/3/25, my lord. Yes, my lord. Paragraph, my lord. 6, my lord. Page number 1.
So,
120.
There is a clear averment that you have been terminated.
That's the standard affidavit, my lord. But we say that this termination orders were never served on us. It's only through an affidavit that they inform this on the court. Because the earlier affidavit which was filed, my lord, there was an earlier affidavit filed, my lord, on 29/11/2024. In that affidavit, they have not taken this stand. Now to circumvent, my lord, this payment of salaries, they've taken this stand. This is our case, my lord.
2911.
Yes, my lord. That will not
Filed by who?
with the sale number, it should be 100, if I'm not wrong, with the 112, I think. Running page, my lord. It's 501 case, Samsul Aslam, my lord. Assistant Chief Engineer, Water Resources Department. There, nothing has been stated.
This is filed on 11/126.
Well, one is filed on 29/11/2024, and the other one is on 11/3/25. The initial affidavit was filed on 27/9/11/2024. There, my lord, no stand was taken that we have been terminated. Because the date of terminations are supposed to be in the year 2023. So almost 1 year after when this affidavit was filed in September 2024, there's not a whisper that we have been terminated.
These termination orders are not enclosed here.
No, my lord, we never received them. That's
No, in the pleadings.
no, my lord, not.
Yes, madam.
Your affidavit as filed in petition for 72 of 25 stated clearly, my lord, that lordship may come to page number 81, my lord. My lord, the affidavit filed in WPC number 4997. And which is
Running page maybe 1, my lord, this may be 126 it starts, my lord. Because I think when you filed was written as 79, but then it was not correctly numbered.
my lord in
It was filed by one, my lord, Samsul Alam, my lord.
Which writ petition?
4997.
Ah.
Here we have filed one affidavit, my lord. Here we have clearly
Not
stated.
one, you filed three affidavits.
Three of it.
You have filed
dated-
an affidavit in opposition on 18 January 22,
Yes.
filed by the chief engineer.
The affidavit, my lord, filed on 11th March 2025.
That's right, but where are the termination orders?
My lord, termination orders has not been enforced, but we have made a statement there in lordship may kindly see, my lord, paragraph 7, that regarding
You have terminated, they have not received the termination order. When are you intending to serve the termination order? Can you serve an order, can you pass an order without service to the person concerned?
my lord, they were engaged purely on temporary basis, my lord, on
And also they are entitled to be served a copy of the termination order or disengagement order.
In fact, my lord, the earlier
regarding, my
affidavit,
lord, their payment, my lord, outstanding payment, my lord, we have made a statement clearly, my lord, that what is the amount due to be paid to them, my lord, 3,72,000 in all, my lord, up to 2023 when they were terminated, my lord.
the earlier affidavit filed on 29/11/2024 by the same person, Samsul Alam, my lord. There is not a whisper that we have been terminated. And the terminations are supposed to be on 1/3/2023 and 1/11/2023. So our affidavit which was filed a subsequent of 1 year after, more than 1 year and 1.5 years after this so-called terminations, that doesn't have been any reference of these terminations. Subsequently, my lord, in order to circumvent the payment of salvage, my lord, they have come up with this 10, my lord.
Because
That
in
we have been
10,
terminated.
10, 122, they were not terminated. They were terminated in
I'm talking
2023.
about affidavit 29/11/2024. It's your affidavit. 22, I was not terminated. I mean, according to you, that's fine. But there will be page number 112, if I'm not wrong, 68, maybe as was mentioned. Your stand in the affidavit. There is nothing, not in whisper that they were terminated in 2023. That's why we filed the second writ petition, saying that these orders were never, this no termination or disengagement order was ever served on us, and we are continuing. And our claim was that of payment in terms of they're being paid rupees 2,000 per month, that too irregularly.
And now what is the amount required to be paid to them?
My lord, as this affidavit, my lord.
So we are claiming on the basis of
In
the judgment of this honorable court, my lord.
3,72,000
In
balance to be paid.
Why has that not been paid?
My lord, due to non-receipt of funds, ma'am.
There are areas, my lord, in that 2,000 rupees, my lord, that was also not intermittent, not being paid, my lord. 2018-19 onward, there are areas, my lord, and we are claiming
This is nothing but absolute exploitation. Sheer exploitation. And totally contrary to the basic protection and principles of the constitution. What is this? You allow these people to work, you throw them out, you don't give them any salary on the ground that funds are evaded. You issue dismissal orders. These orders are not served. Who has issued these orders? Who has issued these orders? He has issued the order of termination.
Disengagement, my lord.
the apex court is saying, no, this kind of terminations are totally not arbitrary and illegal. Jago and all, my lord, the from the court. Apex court has taken note of these, my lord, kind of, my lord, activities. So, I mean, this kind of, my lord, stand taken by the department authorities that are exploiting these people.
Come to page number 127. This is para 6 of the affidavit.
First of March 20.
1st of March and 1st of November. Now you see these statements are made as per his knowledge. Para 10. Not even as per records. Are there records for
Yes.
termination?
There is one order, my lord.
Where is that order?
Then 2023.
Where does one get that order?
Well, it is in the original reports, Madam. It is not before your lordship.
That order is passed, kept in the record, not filed before the court, not served on the petitioners. For what purpose? What is so sacred about this order? Something very sacred, is it? When was the last time you received your pay? Salaries?
Some intermittently, some amounts are being paid here and there. That's all.
No, don't be vague. Give us a concrete information that on this month you received that.
Yes,
much.
sir, they
These
themselves
instructions must be available.
they themselves admitted to these areas, madam.
Mr. Counsel, you stand or fall on your own.
Yes, I do.
So what are your instructions that what is the amount received? And
Well,
for which months?
So, well, what is happening, my lord? They are being paid from time to time some amount, lump sum.
We are asking you there, which time to which time, what amount?
That, of course, my lord, I have to get the instruction. So what is happening? These people are, my lord, giving the lump sum, my lord. They also do not know, my lord, properly.
When did they receive the lump sum? To what extent?
Well,
For which month?
That I can get. That was, of course, but since they have admitted, my lord, that for 2023-24, the last payment, my lord, 16,000 still area remaining, my lord, that. My lord, for 2020-23, my lord, 96,000 areas are remaining.
We are available to give you orders provided you are able to get it out.
But
from us.
that instruction, my lord, of course, like that was not. But
For which month? What was the amount received? And who released that amount? What is the mode of receiving receipt of these amount?
that I
Why are these not a part of the record?
because these amounts, my lord, they are also, my lord, being paid, my lord, from time to time. They also don't know what they're. Sometimes they're paid to this amount, that amount, my lord.
Do they not know where the amount goes? They not know when the amounts are received.
That
From whom?
that I have paid.
And madam, you tell us what is to be done with your orders. You are passing an order, keeping it in the file, and how do you say that they are terminated? The chief engineer files an affidavit saying they are terminated. No orders enclosed. This information he swears in the affidavit to be his knowledge.
I may take your lordship's indulgence, madam. I'd like to file a consolidated affidavit.
There are already 3 affidavits.
Yeah, that's right.
Affidavit,
Fine.
additional affidavit in opposition,
But this,
reply to the additional
Fine.
affidavit, and now you want to file a consolidated affidavit.
are on record, but somehow, my lord, these were not brought before the court, madam.
How to reconcile? The earlier affidavit says nothing, my lord. 11, my lord, 29, 11, 24, my lord. That have been paid 68, my lord. Same person, my lord. Samsul Alam files an affidavit, assistant chief engineer, my lord. There he doesn't refer to any about this termination orders of 2023, my lord. Paid 68, my lord.
Where are your engagement orders?
Engagement orders and retribution, my lord. There, my lord. Annexure 1 onwards, my lord. Page, my lord. 16, man. Sorry, yes, man. 16, man.
Under whose instructions, where did the executive engineer, assistant executive engineering, where does he get the power to issue engagement orders? (1990) It has to be referred to CBI. Make enquiries and fix responsibilities on the persons, officers responsible, and make recoveries from their pension. Merrily go and engaging people, and then when it's time to make the payments, you discharge them. Don't even serve the orders. You put them in the file. You file affidavits after affidavits. Copies are not enclosed to the pleadings which are filed. We are giving you 2 weeks time, you explain your conduct. Or we are referring this matter to CBI for inquiry. Or the CID for inquiry. And counsel for the petitioner is at liberty to bring on record the amount of payment received from which date and in what mode. Heard Mr. M. Dr. Lal, counsel for the petitioner, claim to be serving temporary and casual Department of Public Health Engineering.
Water resources.
Water resources.
Water resources.
Their engagement from 1990 onwards. The petitioners are before this court claiming the benefit. Regular scale of pay as has been granted by this court in case of Pendas. Quoted in the seen that the respondent department has filed several affidavits. One of the affidavits filed by the additional chief engineer terminated discharge with effect from 1st of March 23.
Yes, my lord, and my lord,
October 23.
some, my lord, petition number 1, my lord, on 1st of March 2020, sorry, my lord, 2 to 4 on, my lord, 1st of March 2023, and my lord, 1 from 1st of November 2023.
Petitioners 2 to 4 were terminated on 1st of March 23 and petitioner 1 was terminated. However, no termination orders stated to have been issued by the department are affidavit filed. There are the counsel for the petitioner also disputes the permanent the affidavit termination order and their claim that they are however current and area pay remuneration claim. Standing counsel and SP Chakravarti to file a consolidated to bring on record the relevant termination issued to the petitioner and as to whether copies of this termination order were served on the petitioner. Allowed to be engaged as temporary or casual workers under the orders issued by the assistant executive subdivision. Let this information be placed before the court in 2 weeks. So, petitioner, counsel for the petitioner is also given liberty. Bring on record, price the court, the payments, schedule of payments which were received by the petitioner and the period for which these payments have been received. That will be listed again after 2 weeks. After, counsel for the parties are at liberty to make a mention before the court once the affidavits is directed are filed before the court.
Can I prefer it?
File it, then prepare it.
2000.
You're claiming pension from which department?
Department member, Panchayat department.
Where was your husband serving?
In Salchapra Anchalik Panchayat, my lord. Tax collector under Salchapra Anchalik Panchayat, Kasar Jila.
Yes, respondents.
To the education inspection order. Or is the you send the proposal, but it was returned back by the pension department. After that, for the rectification, it was sent to the CEO, but it has come to them, but the inspection.
When was it sent to the CEO? Page number?
Page number, my lord, 16, my lord.
You're referring to this communication, 2016.
Thereafter, my lord, nothing was done.
Yes. Officer of the state, CEO. Get instructions by Monday. What has happened to this communication?
Engage time.
Question is that you are supposed to be processing this. Why have you not done it? These steps were taken prior to the election notification. Let them come and say that because of the election notification, they are unable to perform their duties. Let them file an affidavit before the court.
What time?
Monday. Get your instructions on Monday. Tell us what has happened. Or we call your CEO. List on Monday, enabling the respondents to complete their instructions as to why the proposal for pension respect of the petitioner, the widow of so-and-so, was serving as the tax collector under
No, my lord, Salchapra Anchalik Panchayat.
Salchapra Anchalik Panchayat has not been finalized. Let these instructions be placed before the court on 33, telling which consequential orders will be passed by the court. You are appearing for? MS so-and-so appearing for respondent 5.
Public.
Most of all.
Last occasion, your lordship directed the respondents to obtain an instruction as to the whether the notification of 17/8/2017.
17/8.
Lordship, a notification is there, issued by the Staff Selection Commission. It says that an outer limit.
Yes,
of
you
180
want to say, where is that 17/8?
at 97.
Item number
Item number 10.
Huh?
Item number 10.
Item number 10.
'97.
97, yes.
this provides an outer limit of 180 days from the date of from the cutoff date as mentioned in the advertisement. So the cutoff date as per the advertisement is 14/10/2024. And if we calculate 180 days from 14/10/2024, so it comes after April 2025, 14/4/2025. So our certificates are
Not all lottery, but some of them are within the 180 days. Some are beyond. My instruction is that lottery in terms of this, my last instruction that this notification will cover, may direct the respondent authority to consider their case in terms of this
17/7, 17/8.
70 days.
That's what we said.
My last instruction.
You have already issued the information, instructions.
Instruction lottery, but their rejection was, my problem is their rejection was from BSF. From BSF, I have not received anything. That's why, but now
But
lottery,
this is
from
page
the
number
SSL.
97
Lottery.
applies equally to all.
Yes, that's why lottery, I got the instruction, it can be disposed of directing the respondent in terms of this. Because all of them are not within 180 days. This series, that's all. Whoever comes within the 180 days, then yes.
So if both of them are not there, we'll exclude those petitioners. Point out which of the petitioners are there or which are not. It's an instruction. It can't be brought on record like that. He's already received instructions, we are going through it. But I don't think
may I make it clear that the issue is slightly different. He says that because of the delay on the part of
because of the delay
on the part of the
issuing
respondents,
authority,
yes, no. So that is
go
covered by
it may go
Ramkumar
beyond
Mishra.
180 days.
Yes.
That is your
Yes. So
concern.
his matter may be untaken with our matters concern. He has the issue raised in this petition is slightly different.
Where is the judgment of the effect?
That Ramkumar gives us judgment, it says that if there is delay, then it can be
Delayed by the issuing authority.
By the issuing authority.
But when you have applied, it has to be also taken it to consider whether before the last date of submission, whether you have applied for that or not, it has to be considered. Yes. When you have applied for that.
That is not.
Yes,
That was the division bench judgment that was completed. Thereafter, it was referred to the larger bench. Larger bench stated my interest.
Different. Taxiera is different. Different.
Taxiera in my respectful submission will not cover his case.
Taxiera.
So on that, I have not gone through these matters. This Ramgop, this case I did not go to matter. So I will take up on the opening matter.
So why reopening? You go through it, take it up 1 or 2 days later. All right. Why reopening?
Because 9 and 10 are holidays and some holidays are also there, so I am considering that. No, that is my I'm understanding, because the next week there will be only 2-3 days.
Huh?
Next week.
31st?
Oh, no, wait.
31st? Have it on 31st. The request made by the council for the petition. You are appearing in which matter?
Item number 9, man.
Item 9.
Not 9.
No, not 9. I think 30, 14.
14.
14. Okay. I could have it. Accommodation for the matters are fixed on 31st. They told me that 31st an attempt will be made to dispose of the matter. Take up everything on 31st. Find that it is different, we'll segregate it. There are copies.
Lordship, let it be there, Lordship.
You have copies?
I have. Item number 39, Lordship.
Oh, right. Item 39
And the notice
will also come together on
notice has not been
31st.
issued yet. Notice has not been issued.
Need not be, should it be issued?
Lordship.
Not necessary.
Obliged.
31st.
Right.
Chief, Fortunately, trial is on legs in general court. Matter may be taken some other day, Lordship.
Have you informed the counsel for the petitioner?
But the last 3 days, 3 postings, every time the same submission is there. It was complete. Right. And again and again, the same submission. Short date, every time short date. They want to file the written submission, they file it. They also oppose it.
As a completed their argument. We are only keeping it for
Well,
whatever.
he also argued,
uh,
only wanted to file the affidavit, affidavit has been filed. He also wanted to know whether any of the regions were there or not. She was that when the reopening notice, 140 notice, it was said that the particular amount was received. And we submitted that no amount was received, the amount was paid for purchase of the goods. Now the judgments of the various high courts are there, that the regions recorded in for the reopening of the assessment, one cannot go beyond that. So once you have recorded in the regions that amount was received, you cannot thereafter pass an order on the ground that the amount was paid.
Contrary to the reasons disclosed. When is he? Huh?
This matter on the 30th of March.
30th of March.
Lordship.
30th of March, not possible.
First,
7th or any late later. Dr. Saraf, 21st, 23rd, whatever date suits you. 23rd of April. 23rd of April. And we are closing the matter on that day.
So you don't get for their send it before also. Then the matter was there for further hearing. Matter before you also. So directly to be listed today.
Another matter.
You'll have to bring it to the notice of the registry. Heard
The last chance, my lord.
Dr. A.K. Saraf, Senior Counsel, assisted by Mr. Bora. Bora. Commissioner, and MS
R. Hussain, Lordship.
R. Hussain, appearing on behalf of Mr. SCKL, Standing Counsel, Income Tax Department, who submits that the matter be listed on another day, enabling Mr. KL to complete his submission to the court. Since the petitioners have already completed their submissions, matter is pending only for the submissions to be made by the Standing Counsel Income Tax. We fix the matter on 23rd. Matter is fixed on 23rd of April. And on which date attempt will be made to dispose of the matter. 23rd April. Yes, Captain. Yeah, Lordship. Directed to submit the
Records, my lord, are received, but these are photocopies, Lordship. The original records are not available.
Why are they not available? Why are they not? Discipline, this is the without procedural option. And all the director has, as per I am the clerical assistant. Director appoint the one person, but I am the victim. All right, heard counsel for parties, the records of the proceedings, as this matter pertains to a challenge to the disciplinary proceeding, records for the proceedings are called for. However, the learned counsel says the original records are not available. She prays for further time. Please again. For what, admission or hearing? Admission. You'll have to hear the matter. Calling for record, you'll have to list it for hearing. Let it be in the month of May. Matter issue rule for the record, hearing, the part 2 hearing list in the month of May. Will be in the part 2 hearing list, you make a mention. You make a mention for upgrading, we'll take it up. Part 2 hearing list for the month of May.
Take the seat after some time, Lordship. Senior on legs. Senior on legs, Lordship. After some time, Lordship.
What is the matter about?
We have filed a affidavit, my lord. We are yet to file any response.
You want to file your response? No.
Lordship, today only.
Huh?
Today only we will do, Lordship. We are ready, Lordship.
You are ready, all right? After some time.
Lordship, may kindly pass over the matter for time.
Possible.
Lordship, the item may be taken after some time.
We are referring it to mediation. What is it? Release of subsistence allowance. Matter is referred for mediation, parties to appear before the Gauhati High Court Mediation Center on 6th of April.
For mediation in 6th of April. Much of that.
Matter be referred to mediation. Call it up after a while. Then yes, mediation.
No, the allegation is the sexual offense.
My lord, we are yet to file affidavit in this.
After 2 years.
Dismissal from service, my lord, on the allegation of sexual.
You want to file your affidavit, file it quickly.
My lord.
The respondents are yet to file the affidavit, although notice in the matter was issued as per Vehicle 7/6/24. Final opportunity granted to the respondent. File their affidavit. No further opportunity will be enlarged. Matter be listed after 4 weeks for admission. March already. Mr. Reyes Biswas for petition and Mr. Hardball for stay. All right.
For the time is 26 months.
Nobody appeared, so we passed over.
I think one of the counsel for the other side, he was talking about finding some affidavit, he is also not here. One affidavit I have received, but this is another from respond number 6.
Who is the respondent for the other? You come back after a while.
Yes.
You inform him. Come back after a while.
He was to come here. He has come.
Lordship, the affidavit is ready. Lordship will be filing it during the course of the day. I'll just serve him a copy right now.
You want? We'll place it after 3 weeks.
Yes.
Not 3 weeks, let it come before the election. What the matter relates to my lord?
No. We want to know whether you might like to file a rejoinder or not. The affidavit that
Actually, the matter is this. We don't always like to file a rejoinder.
So therefore, we have included that time. So if the affidavit is filed by tomorrow, then within 2 weeks we can hear it. But the question is whether your friend will be able to file it. We don't know.
Lordship, I'll be filing it during the course of the day. That will be recorded.
Mr. D. Upaman, counsel for the respondent, submits that he'd like to file the affidavit. Matter therefore be listed after 2 weeks.
The first week of
First week of
April.
8th of April.
Fine.
On which, by which time the petitioners may file their rejoinder, if so, at least in the meantime.
March of.
Highly appreciate.
Give us 5 minutes, we'll come back. Is the inquiry report? Here, along with the requisition itself. Page 44. Huh? What? 40? 44 is my department inquiry report, my lord. Relevant portion 48. Right, so some my lord is
Just like some relating to witness
The deposition.
deposition. Preliminary inquiry.
CHM.
Havildar line, right?
He's in charge of the group.
Yes, madam. When you measure Havildar.
Here are the day-to-day orders, the inquiry. Yeah. Second. Yes, counsel for petitioner, you want to go to the records? Yes, please. The presence of the counsel for the response. Because it appears that you have been given opportunity, you have declined.
Not my argument that on that point. My argument is that the punishment which is imposed on me was disproportional to my alleged acts.
What are the offences? You have left the post of command.
Yes. Is there a case that I had left while I was posted on sentry duty and quarter guard duty respectively, and that I have left without informing anyone?
You're creating a ruckus outside the campus is secondary.
Yes.
But the fact remains that you were given the responsibility without informing. That is a more heinous offense under section 9H.
My lords, in my humble submission, that would not cover my case, my lord, because it talks about leaving the post or party in search of plunder. My lord is referring to 9H,
Or 9I,
which is guard.
9I.
No, my lords, because the records would indicate that I had duly signed a register. Well, while I was posted on
But
duty.
were you relieved from duty?
I was not.
Then, if you are not relieved from duty, you can't go out without the such permission from the authority.
However, the dismissal order, my lords, indicates my dismissal on another ground. It says that apparently I had misbehaved and threatened to kill a colleague of mine, because of which I am not fit to be in service. However, apparently there was a written complaint that was given by one Joy. However, my lord, that was never exhibited, that was neither brought on record. I never
Where is the procedure for the inquiry? Is it laid out anywhere? Act under rules.
27.
Rule
Rule 27, my lord.
27. Case 25.
27 clause 3, my lords, clearly states that when documents are relied upon in support of a charge, they shall be put in evidence as exhibits. The accused shall, before he is called upon to make his defense, be allowed to inspect such exhibits. Now, clearly, my lords, in the article of charges, this threat to kill Bononjoy was never mentioned in the first place. However, the dismissal order reflects that as a primary ground on which I was deemed to be mentally unfit and incapable of serving in the force. Now, they say that there was a written complaint which was given by Dhananjoy against me, indicating that I had threatened to kill him. However, that document was never brought on record, neither was it exhibited, my lords. Therefore, to
So
dismiss
what
me-
document? It's a statement you made.
My lords,
It's not on the basis of, it's not a written letter or anything like that.
it is, my lords. They have clearly written that.
They have given a statement.
No, my lord, they, uh, my lords, if I may draw my lords' kind attention to page 66.
There was a judgment of this court where perhaps the question of providing you with a defense assistance was ordered. I faintly recollect. Not mentioned in the rule.
My lords.
Take up the judgment of coordinate bench. At least two judgments. Here the question of whether defense assistance was required to be given or not. Notwithstanding same not being there, I'm not sure whether it is CRBF.
Lords, may kindly come to page 48. This is the departmental inquiry report, my lords. It's page 48, my lords. This is the inquiry report, departmental inquiry report. The second para, my lords, if I may read. Statement of 9 witnesses. My lords has the para.
Statement of
9 witnesses. The second para, my lords, in page 48. The statement of 9 witnesses were recorded in the presence of delinquent force number so and so, JJ Gogoi, and force number so and so, Biplab Bora. Both the aforesaid delinquent expressed agreement with the evidence given and refused to cross-examine. Constable GD JJ Gogoi admitted his guilt while agreeing to a written complaint made by witness number 3, Dhananjay Dwivedi, that force number so and so, JJ Gogoi had misbehaved with him and had threatened him and let me come out of arrest. I will not leave you. I will kill you. Now, this is the main allegation on which I have been dismissed. And apparently, there was a written complaint.
why do you say it is the main allegation? This is one of the allegations.
My lords, this is the main,
Main allegation of misconduct is giving the
My lords, but
without
the dismissal order does not reflect it, my lords. My lords, page 66. Page 66, my lord looks at para 8. Reads, from the evidence of the aforesaid witnesses, it is clear that force number so and so JJ Gogoi threatened to kill HCGD Dhananjay Dwivedi, CHM, keeping in view the gross indiscipline exhibited by JJ Gogoi and the express criminal attitude and the mental makeup, and also keeping in view the adverse effect it would have on the force. This kind of indisciplined and irresponsible person should not be kept in the force because it is necessary to keep with arms in the force, and a person such criminal mentality and ill motive may cause any untoward incident at that time. Thereafter, the order has been passed.
this was also one of the evidence given by the prosecution that you made to utter this statement.
Yes, but those were never exhibited because admittedly it was in the form of written
Right,
complaint.
it was the written complaint is not there. But there is a evidence of one of the constables who had accompanied the PHN. Bring you back to the camp. Said I was there, I saw him and uttered this statement. But the statement was there. You did not cross-examine.
And perhaps there could have been a minor scuffle. That is a different matter. But the main allegation was that there was some misbehavior which was done with the OC and some behaviors that were not suited as per the discipline of the force. However, even in that case, even the OC was never called in to support the allegations, my lord. Therefore, the main allegations were against me of misbehavior, my lords. Those cannot be relied upon because the material evidences were never brought on record. And so far, my lords, unauthorized absence is concerned, my lords, I humbly submit that I had left my post, but that was not abandoning my duty in totality, my lord. I had gone out for withdrawing money for some time, after which I would have come back. But due to the unfortunate circumstances, I got embroiled in this whole event and I had to go to the police station, because of which I could not come any sooner. And then the allegations followed. My lords, in my humble submission, all this does not entail my dismissal, my lords. This is a punishment which is much harsher than what I have actually done, my lords. I admit that there has been some inconsistencies on my part. I should not have abandoned the post like that. But my lords, it was only for a small time, my lords. The other petitioner, Biplab Bora, he did not engage in any of this, my lords. He neither threatened, neither he had engaged himself in that scuffle. Therefore, that matter, yes, sir.
Ready? Please submit. It is fall under section 9 or 10. That will be scrutinized, my lord. Otherwise, my lord, everything you can oppose the my lord, and the left, my lord, on his own guilty, my lord. Here is my lord, FIR also the police case is registered, my lord.
Another issue, Manat, I admit opportunity is given, but was it given for the sake of given, to be given? Because that it was given, admitted, but was it fair enough? Was the environment conducive? There's a judgment which covers my case, my lords, which speaks of such self-admissions and such opportunities. My lords, Kripesh Chandra Roy reported in 2007 1 GLP. Page 100. These are also my lords, CRPF constables. They were charged with of running away from the post, leaving their weapons behind.
Yes, yes, yes.
My lord, I have placed the judgment that I have given.
Yes.
This case, my lord, pertains to the petitioner was a serving constable. They were charged of that he ran away from his post, abandoned the post, and with left behind the arm. So, my lord, there also opportunity is given, but paragraph 4,
Oh, paragraph
4, my lord, paragraph 4 ends at, it starts on examination, my lords.
there was also opportunity given so and so, but after going through everything, Lordship, the Honorable Court at the next page, just above the para 5, had held that the examination by the shall I read, man? The examination by the court in a matter of a disciplinary proceeding would naturally only to see whether the procedure adopted was fair and reasonable, and whether reasonable opportunity was available for the charged person to defend the charges leveled against him. In the present case, the responses of the witnesses produced were absolutely parrot-like and mechanical. It gives the impression that irrespective of the actual deposition, uniform responses to suit the findings have been recorded. The fact that the charged constables pleaded guilty as well as declined an opportunity to cross-examine the witnesses introduced to prove the charges indicate the proceedings were not in a free environment when were conducted in a manner where the charged constables were prejudiced from freely participating in the proceeding. The delinquents were obviously awed or overwhelmed by the presence of a superior officer who was conducting the inquiry proceeding, and fair opportunity was denied to them. In this case, my lord, that legal assistance issue also came up, that para 5. It was denied that under CRPF Act and rules, there is no provision for such. Court went a bit further and examined everything. The court, while examining the proceeding as indicated above, has found no fair and reasonable opportunity has been provided to the charged constable. Such a finding of the court is not reached on the basis of fact and legal assistance has not been provided, but on scrutiny of the proceedings as a whole, which has led this court to conclude that the fair and reasonable opportunity was envisaged while law have not been provided the inquiry wherein guilt finding had been recorded by the inquiry officer. Considering in the light of the above submission, this court finds a finding that insurance is liable to be interfered, and following finding is set aside. And consequently, the imputed order of punishment whereby compulsory retired from service as well as the order that a so and so appeal file has been rejected were also set aside. He was given the consequence.
The paragraph 4 speaks on examination of the court. The matter disciplinary proceeding would necessarily be only to see whether procedure adopted was fair and reasonable, and whether reasonable person was available for the charged person to defend the charge level. So if the record is there, man, record speaks, man, the reasonable person was given, man. Every day, man, he was given, man.
What do you say with the objections raised that the basis of dismissal was on the indication that you had threatened this company with a measure at the time when he
conclusion of the inquiry officer was not reflected just it was only this there is a complaint or like this conclusion of the inquiry report inquiry case 44 51 the conclusion while concluding the inquiry officer, I have to say that so and so was deposited on a guard at gate on so and so while posted at the various sensitive area in an active duty. He left his post of duty without permission from the competent authority at so and so. He went outside the premises, went to the person and the misbehaved support the comprise of so and so. With regard to the incident, I have to say that sports below details. But during checking the guard commander's 16 hours on 17 during the checking, constable was absent. Being a member of the reserve police, leaving the camp without permission of the competent authority, and riding a motorcycle to go to the Bukazan and meeting his employees of the Bharat Petroleum located here was exhibited in the duty and discipline. The opinion after going through
is there any dispute that the witnesses were not examined in your presence?
No, they were examined. But I'm trying to say, my lord, because we see the translation of, if you read, the common thread is that I have abused, one of the petitioners has abused their superior, Dhananjay, But whereas it completely deviates from the charge, article of charge doesn't speak anything, doesn't have any whisper. The charges are very specific that I was absent, go to absent. It doesn't whisper a word about Mr. Dhananjay. But when you punish me, you bring in Dhananjay in the picture. If the article of charge at page 28, Lordship, page 29, Lordship reads, the Lordship will find what I am charged with and what are their findings. And also, that concept is very clear. Preliminary inquiry should not have any bearing on the regular inquiry. But if you go by the translations provided by the learned CGC, my lords, you will find the preliminary inquiry has influenced the regular inquiry, because preliminary inquiry also says that Dhananjay, that Dwivedi was charged, my lords. And it's a settled law, my lord, that evidence recorded in the preliminary inquiry cannot be used in a regular inquiry. But here, my lord, they charge me with absence. And in preliminary inquiry, they deviate from that and go something which is totally alien, that I have charged, I have misbehaved with my superior, some other colleague. And another aspect, my lord, the punishment inflicted, my lord, in my humble opinion, is, my lord, totally disproportionate. In fact, Lordship will see the translation provided, my lord, at page 7.
Yes.
In fact, my lord, that star witness, my lord, Dwivedi. Lordship takes the
Dwivedi is the CHM.
CHM. Upon whose edifice, my lord, they are trying to have my punishment, my lord, justified. Page 7 of the translation provided, my lord, the questions, my lord.
Yes.
Page 7, my lord. Questions asked to force number so and so, Dhananjay Dwivedi. The first question, my lord. Page 7, it's marked as page 7.
Page 7.
7. Statement of Dhananjay.
Preliminary inquiry. What is preliminary inquiry got to?
No, my lord. Because, my lord, because in preliminary inquiry, there's a finding that now you can go with a regular inquiry.
Page number?
Page number 31, my lord. The opinion of the person who conducts the preliminary inquiry. It's the opinion of the inquiry officer. I'm reading para 5, line 5. Here also, my lord, there is no assuming, my lords, we are guilty, but Dwivedi doesn't see anything about he was being, he was abused, he was gully colors, nothing, my lords. Dwivedi and Wade, though I have not challenged, my lord, has no foundation to proceed, my lord. And the article of charges are very clear. I'm absent. And I quarreled and threatened abusive language engaged against the employees of the Bukajan filling station. They will also not examine my notes.
Let us assume that punishment was imposed on something little more than what the articles are.
Yes.
It was well, it was, the opportunities were given to you during the inquiry. It's not a case that the
Yes.
inquiry proceeded on the articles and
Yes.
something else on the basis of which you were given. It's a part of the inquiry.
Well.
You were given, you were confronted. Why did you say? What did you say? Third angle has to be read into the article because then if we give you the benefit of not being well versed with law, raised an objection that this is not a part of the article. So these are not part of the article of charge. So therefore, there was no written statement. File a written statement.
It's correct for the sake of assumption. Then
No, not assumption. It's hidden in the records. From the records.
then I'll approach it from a different angle, madam. The proportionality, madam. The punishment imposed is disproportionate. Because first thing, my lord, there was a FIR. I was not charged. One of the petitioners was not charged. Nothing found against me. Because if we fall back to again that absence, that willful absence, that has to be that in the light of the judgment of Christian can't be Parmar, my lords. That element they have to assess that it was
Christian
willful.
Parmar is on overstay.
So
You are on
overstay
guard
also,
duty.
but it was overstay, but it has a element of absence also.
No. Krishna Kumar is on overstay. You
Overstay,
were supposed to join, you did not join, so you gave reasons you are not well, sick, hospitalized, death in the family, etc.
Exactly.
Here is a case, you know what your duty is. You are there. You signed, you went out.
I signed and I went. That is it.
Is it a case that you are permitted to do so? Or it's not?
Well, in fact,
is it a case that if you sign, you are permitted to go out, otherwise you are not permitted to go out?
But the
that is not a defense taken up. That's not a defense.
Then I'll go to that proportional issue. I am relying on a judgment Mukul Kumar Chaudhary. Even if I admit, I went out. It was in their knowledge because I signed. There are witnesses who saw me. Had it been a case of desertion, I could have went out secretly. Nobody would have get anything. The penalty which was imposed by the disproportionate because I did, and my past service was not taken into consideration. I was like,
who was the person who was in charge of the particular post? Who was the person?
Well, I'll answer that one. She will take it away.
Yes, Mr. Muruthan.
37. So, heard the matter earlier. Walking through is appearing, possibly 3 years has come is being away. See. Second, I have got some difficulty.
Indigenous.
Yes.
Indigenous.
From this side.
Inform the other side.
Yes, we have already discussed.
I appear on behalf of the petition.
All right, we'll hold it up after 2 weeks.
My lord, the date we have agreed on 30th of April.
30th of April.
My lord.
All right, 30th of April.
Interim order may be.
Interim orders. You can- Yes.
Before breaking for lunch, my lords had put a query as to who was in charge of assigning the duties. I've consulted my learned colleague. So perhaps it is the Inspector GD Ashok Kumar Chaudhary who was discharging his duties as Subedar Major. Subject to correction, perhaps he was the person who was in charge of assigning duties. I had perused the questions raised to Ashok Kumar Chaudhary in the preliminary inquiry, my lords. There was a pointed question which was raised whether did CTGD JJ Gogoi and Biplab Bora submit any kind of application to, with a permission to go out from the camp on 27/5/2012, or any order permission was given them to do so. To which he replied, "Sir, both the CTGD did not submit any application to me, nor did they inform me about any such application to go out from the camp." That is his reply, my lords. Therefore, from this, perhaps it can conclude that he was the competent authority.
Mr. Bedi, even the translations in page 35 of the translation of the inquiry. Page 35 of the inquiry, not preliminary inquiry. Yes. Translations. Yes, ma'am. There is a question put to the delinquent officer, delinquent employee, whether he has anything to say in respect of the statements made by GD Ashok Kumar. Yes. Now, where are the statements of Ashok Kumar Chaudhary? Ashok Kumar Chaudhary. Yes, sir. That's the only statement.
Yes, sir. On preliminary inquiry, statement over there.
The preliminary inquiry, yes. Was any opportunity given? Or petitioners cross-examine. There are judgments to say that preliminary findings in the preliminary inquiry cannot be used unless opportunity is granted. Where are these line of judgments? You can't expect the court to find out judgments for you. You have to be ready to argue the matter. Find out. Let us know. We'll have it. We'll continue on 30. 30. For further hearing on 30. Argument.
Record मेरा file.
Original record.
I'll
You take it back.
Yes, but
Give it to us again on 30.
yeah.
Record to ready to this table. And timing. Hello.
My lord. My lord, I'm affected, aggrieved by the seal cover procedure adopted by the respondent authorities on the ground that criminal cases pending against me. I was supposed to be promoted from assistant executive engineer.
There is no departmental proceeding.
There was no departmental proceeding. There was no charge sheet on the day when the minutes were drawn and my promotion was kept under seal cover. Now, the respondent have filed an affidavit and therein they have stated it is their admitted position also that there was no departmental proceeding and no charge sheet were there. But they are saying that prosecution sanction was obtained from the authority and that is their basis. But that cannot be, my lord.
This is the judgment that was enforced this judgment.
Yes, man. Kindly come to paragraph 22 onwards. Paragraph 22 onwards.
Judgment is by the state. You filed your response. I rejoinder.
My lord, we are not filing.
No rejoinder necessary.
Not necessary, my lord. The judgment only answers. They are saying that prosecution sanction was obtained and that is the basis now. This judgment says para 22, 23, 24, 25 and 26 makes it clear that even if there is a prosecution sanction, that will not do. Even if there is a charge sheet at a later date, when the minutes were drawn, after that, there is a charge sheet, that will also not do. This memorandum says, government serving in respect of whom a charge sheet has been issued and the disciplinary proceedings are pending. That is the criteria. Annex the basic.
Your case, the charge, when was the prosecution obtained?
Prosecution sanction, my lord, 19/11/24. Whereas DP, my lord, DP was held later than prosecution sanction. DP was held on 6/3/25 DPC. Department Promotion Committee meeting on 6/3/25, and procedural sanction was given by the governor on 19/11/24 prior to, my lord, the DP. Now, my lord, let him file it on affidavit that, my lord, on the date when this procedural sanction was, my lord, given, and between DPC, no charge sheet. Since there is, my lord, no police or enforcement department has been made a party, it's a little tough for me because being an PWD to get a charge sheet, my lord. What the PWD, my lord, has obtained, my lord, that is a proceedings sanction. That is on 19/11/24, apparent, and DPC after 6 months. Let him, my lord, bring it on record, my lord, that charge sheet was not filed.
No, first you tell us what is the ratio in the judgment which you have enforced.
Oh, my lord, yes, and
You have enforced. Where? In your writ petition.
Yes, my lord. Page 74. I read, my lord, para 24.
You read from 20 years.
22.
From
Landed
20,
counsel.
from 20.
20. Discussion and conclusion. The core issue for consideration before this court is whether by mere grant of prosecution sanction it could be said that the prosecution for a criminal charge is pending against the respondent government servant, and whether grant of sanction for prosecution could be a valid ground for putting the DPC recommendation seal cover. On a bare perusal of the OM dated 14 September 1992, which covers the issue, it's clear that it prescribes the conditions under which the assessment done by the DPC is to be kept in the seal cover. According to this OM, the seal cover procedure can be resorted to with respect of 3 categories of government servants. That is, government servants under suspension, government servants in respect of whom a charge sheet has been issued and the disciplinary proceedings are pending, and government servants in respect of whom prosecution for criminal charge is pending. Learned Counsel for Appellant made a pertinent submission that the case of the respondent falls under the 3rd clause of the above OM, that is, government servants in respect of whom prosecution for criminal charges is pending. Thus, the question requiring consideration is as to whether a mere grant of prosecution sanction would be sufficient to infer that the prosecution for a criminal charge was pending against the respondent. Similar issue came up for consideration before this court versus KB Janki Raman, wherein it was held that seal cover procedure is to be resorted to only after the charge sheet is issued. The relevant extract is reproduced below. On the first question as to when, for the purposes of the seal cover procedure, the disciplinary criminal proceedings can still have commenced, the full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal prosecution is issued to the employee that it can be said the departmental proceedings, criminal prosecution is initiated by the employee. The seal cover procedure is to be resorted to only after the charge memo, charge sheet is issued. The pendency of preliminary investigation prior to that stage will not be sufficient to enable the authorities to adopt the seal cover procedure. We are in agreement with the tribunal on this point. The contention advanced by the Learned Counsel for the appellant authorities that when there are serious allegations and it takes time to collect necessary evidence, prepare and issue charge memo, charge sheet, it would not be in the interest of the duty of administration to reward the employee with a promotion, increment, etc. does not impress us. The acceptance of this contention would result in injustice to the employees in many cases. As has been the experience so far, the preliminary investigations take an inordinate long time, and particularly when they are initiated at the instance of the interested persons, they are kept pending deliberately. many times they have resulted in the issue of any charge memo, charge sheet. If the allegations are serious and the authorities are keen in investigating them, ordinarily it should not take much time to collect the relevant evidence and finalize the charges. What is further, if the charges are that serious, the authorities have the power to suspend the employee under the relevant rules, and the suspension by itself permits a resort the still covered procedure. The authorities thus are not without a remedy. At this stage, it is pertinent to note that the Ministry of Personnel Government of India by OM dated 2nd November 2012 issued certain clarification regarding the stage when a prosecution for criminal charge can be said to be pending. Keeping in view the dicta laid down in K.V. Janki Raman,
Now, here, when was the DPC held?
DPC held on, my lord, 6/3/2025. 6/3/25.
page 45.
And proceeding sanction, my lord, 19/11/24. Prior to, my lord.
Sanction is not sufficient. When was the charge sheet?
My lord, the thing is that
27/11/2025.
charge sheet.
27/11.
2025. Charge sheet certified code from the court.
Prosecution sanction not enough to put it in a seal cover.
Janki Raman. My lord, I was not aware of this charge sheet because it's from a different agency. They are not a party here. So this is the news to me, my lord. Let him bring this on.
On the day when the minutes was held, DPC was held, there was no charge sheet. Only prosecution sanction.
Yes. Only person is mentioned.
That in terms of the apex court judgment is not sufficient. Have you gone through the apex court judgment?
Yes, my lord. Janki Raman, I am aware.
Not Janki Raman, the subsequent one,
My lord.
enclosed to the writ petition.
Yes.
Only Loye.
Yes, my lord.
Very clear. Principle in Janki Raman is being followed. Where have you stated in the petition about the charge sheet?
My lord, it was from their submission that we could gather that charge sheet was there. It was their submission during the pendency of this writ petition before the court. Then we found out from the court below, the trial court, about the charge sheet, and we have obtained a certificate.
Bring it on record. Bring it on record because you are contesting, you are disputing their contentions that charge sheet was there.
No, but our contention is
Otherwise, my lord, he has to bring this on record, my lord.
We don't want the entire charge sheet to be brought on record. We are saying that at least the statement that the charge sheet collected or certified copy reveals this is the date.
At least the past 2 pages.
What is your stand in the affidavit regarding the seal cover?
Seal cover, my lord. Our stand is that, my lord, since they are the proceeding sanction prior to DPC, my lord, we could not adopt, my lord. Already proceeding sanction was given, my lord, on 19/11/24. And DPC held on 6/3/25.
Here is the statement that charge sheet was filed. Statement.
My lord, we have already, this is our case, my lord, paragraph 15. We have specifically stated that no charge sheet was there.
No, you submitted that the respondent authority had stated that some charge sheet was there on record or file. But their affidavit does not disclose. So.
It was verbal. My lord, for a moment, kindly come to paragraph 15 of my unit. Paragraph 15, my case is there, man. Paragraph 15. Paragraph 15. Now, my lord, kindly come to the next page, page 15, which is continuance of paragraph 15. Next page. My case is there, my lord. Admittedly, first line, my lord. Admittedly, no charge sheet has been filed in Vigilance PS case number 1 of 24 till date, and as such, it cannot be said that there is a criminal case pending against the petitioner.
No, we understand your submission. What we are trying to find out. While ago, you submitted that the respondent's stand is that charge sheet was filed earlier.
But now they are not taking that step.
So we are asking you, is it there in the affidavit?
No.
When did they take this stand and where?
They have not taken, on record, they have not taken. My lord, only to the query of the court, I have mentioned the date of charge sheet. So, query from the court, so I made a statement. My case is that, my pleaded case is that there was no charge sheet on the day of drawing the minutes, and neither their case that there was a charge.
Your case was not put up. Is it put up?
My case was put up, my lord, considered and kept in seal cover.
Where is the finding there?
But kindly come to page 46. There are 10.
Is there any circular or notification to that effect?
My lord, I think there is an, that effect, my lord. There is an OM, my lord.
Where is that?
I will try, no, my lord, it's not annexed here.
OM, my lord, page 61. And notification is of 30 August 2022. Well, it is shown at page 47, serial number 15.
Charge sheet was filed on
27/11/2025.
Of Assam, my lord.
what about government of Assam?
My lord, here is my lord. I'll have to get the instruction, my lord. My lord, and my priority, my lord, let him bring at least the first 2 pages of the charge sheet, my lord. That is his case. got on record, my lord. It's unnecessary, my lord. No, that is
Unless there is a circular notification to the contrary. Down by the charge sheet file also is okay. Or proceedings initiated. Say that no, there is a charge sheet available.
That-
then we can direct them to bring it on record, whatever the whatever. There is no averment in your affidavit.
The thing
that
is
there
that,
was
my
a
lord,
charge sheet file.
my lord, the thing is that PWD, my lord, is an administrative department, whereas the case, my lord, is under vigilance. Say, my lord, are altogether. So we could not get that information whether charge sheet was filed or not, my lord. Was and vigilance is not a party in this case.
Filing affidavits and petition, give an idea of what your grounds for argument would be. Come to paragraph 6, page 82. Fifth line. Fifth and sixth line.
And that is what procedure section was we initiated. My lord.
Your case is, it was put in seal cover because of prosecution sanction.
Yes.
Your case is not that prosecution sanction and then charge sheet. You may not have a charge sheet, but you have information charge sheet was filed. Your case is that prosecution sanction, therefore seal cover. Under 197. And see the last line, so under so and so seal cover procedure was adopted.
Clearly, my lord, sometimes it happens, my lord, why we did this. Sometimes it happens, my lord, prosecution sanction is given later. Charge sheet is filed.
Going on some other line, we are on this law. You have to tell us whether Janki Raman is applicable in the state of Assam or not.
Yes, sir.
It is applicable. So if it is applicable,
It's for the whole of the country.
then no, not like that. You may have a circular to the contrary.
My
You
lord,
always have a circular office memorandum to the contrary.
there is an, so far I remember, my lord, there is an OM, my lord.
Right. Get that OM. Tell us that
There is a, my lord.
it is available.
Personal department has an OM regarding this, my lord. My lord, that OM at page 61, I have annex.
You have annex.
Yes, my lord. No, my lord, that is of 2006. It's a 20-year-old OM, my lord. For I remember from 19, there is an OM. I will get that. My lord may fix it next week, any day, my lord. Part heard.
Tuesday,
Tuesday.
31st.
But and we kept as partners.
Yes, heard counsel for parties. As matter had to be referred for circular which the council, the state council submits. Available. Which the department had kept the case of the writ petitioner in seal cover. Which the PPC constituted by the department had kept the case in seal cover. Based on 31st for further hearing. Matter be treated as part of. Says there is a circular. He says there is some circular that prosecution sanction available sufficient to put in.
Yes, but that's the kind of some other circular. That circular, kind of.
There is a circular which provides that prosecution sanction sufficient to put the case of the that is what you are trying to find out.
And I will try to find out if there is any other further circular matter, personal department, if they have any.
All right.
I'm grateful, man.
Overweight by 8.5 kg.
8.5 kg. What do you want us to do? We can only direct you to go and get fitter by the day.
That's it.
That's all we can do. 8.5 kilos overweight.
Okay.
People are fighting tooth and nail for 0.5 kilos and 2.5 grams and all that. You are coming with 8.5 kilos.
The difficulty is that Lordship on 3/12/2025, he was examined in the detailed medical examination. During detailed medical examination, he was found overweight by 6 kg. And on the very next day, the RME was conducted, wherein he was found again 3 more cases than the detailed medical examination. Now, our contention is that, Lordship, firstly, the reports are contradictory because the detailed medical examination board and the review medical
That
examination.
contradiction doesn't help you because you are otherwise overweight by 6 kilos. Even if we don't consider the RME, but DME, you are overweight by 6 kilos.
Lordship. Okay. But the difficulty is that my contention is that, Lordship, the RME and the DME, they both uses the same machine for measuring the weight of a particular candidate.
How does it make a difference of the 2 extra kilos by RME? We are saying we are ignoring the RME.
Now the issue is that, Lordship, the machine which was used by the DME and RME, that was not in terms with their own time.
Right.
That is my case. That I can show you, Lordship, on their affidavit in opposition.
Affidavit in opposition.
Yes, filed by the respondents. Now that particular machine was itself.
There is no affidavit here.
Affidavit of opposition filed by the respondent.
This is IA.
IA is not there.
Huh?
Item 24 and 25.
Sorry, 7354.
Yes.
7354 affidavit.
Standard test, he qualified the written test. In physical
Very
efficiency,
good, very good.
page 44B, except 4. This is a certificate issued by the capital scale and calibration.
44B.
44B. Certified by proprietor of capital scale and calibration. And this particular proprietorship firm is approved by the Sarkar Monitor 2009 চনৰ অসম যুগ্ম প্ৰৱৰ্তন আইন অনুসৰি মেৰামতি অনুগ্ৰহ সূত্ৰধাৰী।
What is your weight?
70 finding gaming not mentioned, but in RME it is 75 kg. It is to be 71 kg as per considering his height, because his height is 171.3 kg. Now, you also will find the defect in the machine.
Where did you get hold of these documents?
Lordship, it is affidavit in opposition filed by the respondents. Their record.
Yes.
Lordship will find dial is not perfect working. The dial which will show that what is my measure.
What is the meaning of this, Mr. Roy?
Lordship, not lordship, because this was annexed, because they are saying that there was no machine to weight them.
But your machines appear to be not in perfect
It
working.
was when we give it for recalibration, what was the actual problem they have received. It was given after recalibration, it was given to us. Because this is the agency
must be
who
a certificate.
recalibrate.
So there must be a certificate that it
This
is
is the
perfectly
certificate.
working.
This is the they sealed it. They put their seal, Lordship. What we have given to what was the problem, it was there. They thereafter they sealed this machine by their seals, because weights and measurement they seal it. That's why we have given that we have calibrated it before measuring. There was a problem when we given to them. There was a problem. They sealed it and give it to us. The sealing is that the machines are okay.
In terms of their own guideline, this certificate is not legally correct, because their guidelines say that the recruitment centers has to maintain the weight machines approved by the Department of Weights and Measures. Now,
Weights and
this
Measures.
was certified by Capital Scale and Calibration.
The authorized service. That's why Lord, we have annexed it. It was approved by the government. This.
And which is not properly repair.
That's why Lordship, we have this is the
defective
calibration. For calibration, we give it.
It is indicated there that this is in terms of the weights and measures act.
Yes.
That's it.
In the certificate.
Yes. Sir.
So that these were the machines which had some defect. But is there a statement to the defect?
But we say that what the
They have not filed any reply to my application.
Stated here that it was duly calibrated and certified.
Yes, sir.
Lordship. They stated, but if your Lordship peruses page 144 plus 6.4.1, RCs, that is equipment centers, will ensure that equipment to be used during DME be got standardized by Weight and Measurement Department under BIS Bureau of Indian Standards, and the certificate to this effect be kept on record. Now, this is an authorized center, but it is nowhere says that this authorized center maintain its standard as by the Bureau of Indian Standards.
It is there in the
License.
It's there.
License number is
There.
But apparently it's a,
Monunito, so and so, I know.
I understand, I
there.
understand, but apparently Lordship, it's a defective machine.
No, defective machine, therefore it was required for calibration.
Lordship.
That's why we have
The
put this.
very fact that it was defective is sent for calibration. What their affidavit says.
That's why this certificate is
In-
annexed.
In,
to that.
in view of the defect and the subsequent repair, the possibility of
We are not going into that. Why should all this, whether it was measured in this period, that period, in the time when the, tell us the date. It was sent on 29/9/25. When was
25.
your weight taken?
After 3 months.
Huh?
After 3 months.
So you show us from any relevant document to say that no, this calibration has to be done every month, or every 15 days, or every 45 days.
In view of the contrary finding within 1 day.
I can understand 0.05, 1 kilo, 1.5 kilos, 6 kilos.
Actually, the petitioner was made to run for 5 kilometers within 24 minutes. He qualified in that category. He has cleared all
What is
the
the weight
stages of
required? What is the weight required? Minimum,
for
maximum, sorry.
Plus minus 5 kg. As per height, it is.
What is the height?
170, 1.03 cm. Okay. So the weight has to be 71 kg.
So found to be 75.
75 kg. It's a trifling defect, Lordship. It is not that this particular, he being an overweight, assuming that he was overweight at that particular point of time, that will not affect his duty in any manner, because he was the
It's not
person
a question of affecting duty or not. It's a question of whether you fulfill the criteria.
Yes. But
There's
yes,
a criteria laid down.
yes, I understand. He has cleared all the stages of
He
duty.
may have, but he weight problem. You are aware that in defense,
I understand.
the existing personnel are required to undergo medical
Okay.
evaluation,
Okay.
and they are brought up and down in the high medical, low medical categories.
May I humbly pray that because of, though there are contradictions, if the respondents examine him once,
We can't direct him. If you may file a representation, if they desire, they can do so, but we can't direct them.
because I have annexed the certificate issued by the SDM in HO of Tamulpur
You
BTS.
see, weight is something unlike height.
Okay.
Height, yes, we can understand, measure here, measure there, more or less it has to be the same. Weight will keep on varying. It has to keep on varying.
As of now, as per my instruction, now he is the weight as required by the respondents.
If weight did not vary, we'd have been very happy, people like us.
Lordship, in fact,
But
I am also
unfortunately,
suffering
it
from
varies. So, yes, Mr. Roy.
Lordship, let the Lordship has passed the final representation.
He will place judgment which will dismiss my case.
Of course, that's his job.
That he will file a representation in the department.
See?
Lordship.
Not as bad as you project him to be. He has given a judgment where you are permitted to file a representation. But you give him a copy and show it to him if it is.
Lordship, he knows. Lordship, he isn't.
All right. You are the petitioner there.
No, I
No.
was not there, but
So, file a you may submit and the review board may reconsider it.
Lordship. Time
File
frame
it
may be,
within 10 days.
yes, time frame may be given.
There is time frame.
Right, post. Both the writ petition.
No, Lordship, in item 25,
Item 24 disposed. But this is with regard to weight.
he was rejected on account of eyesight. Effective distance vision 6/12 of both the eyes. Your Lordship will find at page 15 the report of the DNA.
Then, do you
Defect-
have any documents from the
Yes,
civilian authorities?
Yes, at page 18. This was issued by the IOPD of Fakulty Alia Medical College, Kolkata. Distance vision 6/6 of both the eyes. May I pray for an order in terms of this document that earlier disposed of. This was also related to eyesight document.
But here, Lordship, he was examined by RME, and the presiding officer is a of RME is said eye
Eye
specialist.
specialist. This this examination by the civilian authority is post RME.
Lordship.
How many days after?
After 16 days, 15 days. Effective distance vision, one can cure it within 2 weeks. Lordship.
See report or civil hospital report.
That in their affidavit, they have not said that they referred the candidate to any civilian doctor.
No, you said
Yes,
At page 18. On it.
180.
1/8.
So this should
This is
by
RME.
No, 18,
18.
18 of
180.
repetitions.
Huh?
18 of the repetition. 17 is the RME report.
There's no page 18 here. Only 19.
Page 16, your lordship will find the type copy of the RME report.
Page 16.
Lordship. Reason for medical unfitness. Distance vision,
Page
right?
17 is the original copy of RME.
Lordship.
There's no page 18 here. 19 is that office memorandum 31. Yeah. Can copy that. Page number 17, I think. Sorry,
18.
18. Doesn't even have a signature.
But this was issued by the IOPD of.
I don't know, but look at the,
Signature not there.
look at this. It doesn't even have a signature. How it has been done? Vision checkup. Who checked up?
IOPD
Is it by the optometrist or by a doctor?
by a doctor.
How do you know? Where's the endorsement by the specialist?
That is not there, but if your lordship perishes the top of the page, IOPD is there. So in OPD, obviously the ophthalmologist.
You produce the original. Let us see.
Lordship.
Third counsel for parties. The petitioner is agreed that his candidature for the selection rejected the ground of defective eyesight. eyesight was found. Is in the court, say in the court. By the medical. Next week. When
The first week of April.
I went on 8th or 22nd.
On 8th.
Eight.
Or 7, not sure if it is possible.
Not 7th, 8th.
Not sure.
8th of unappears. So there is none. Name is so and so, it is for the content.
Water resource.
Water resource. First one. Yes.
I believe my friend on the other side has completed his arguments. First of all the three matters are basically on the same issue. I would be arguing on worship petition 19. That's the
19.
19 of 25, that is non-arranged.
Of 25.
25. Now, the other writ petitions, Lordship, are basically the same grounds are there, the paragraphs are only jumbled. It's basically a copy paste thing. Now, what you will appreciate, the petitioners before your Lordship are employees of the PRO, but they are civilian employees. They are not army. They are not army personnel. Now,
Yes.
and here is the case where not only the petitioner, but there are some other persons also against whom the proceedings have been initiated. And what has happened here is, Lordship, some casual paid laborers are engaged by the PRO for the goods, and normally these are not
those employees who are there, it's not a full-term service, it's on a year-to-year basis. And it was found that some casual paid laborers, they appeared in two different places. Their names appeared in two different places. And why the departmental proceeding has been drawn up
During the same period,
at the same period.
two different places in the same.
Same. So same thing. And why particularly the petitioner has been, Lordship is one of the persons against whom the departmental proceeding has been drawn up, is that he is the person who initiates the process of the payment. It goes from him to the task force and then to the audit and accounts, and then the payment is made. So, and he is the person who has to physically verify whether these people are there or not. Now, how all these things have come to light? One particular person, an office employee, shot off a complaint, and it was also to the President of India. And in the meantime, the process for payment was already initiated. Then the complaint came back, and on that very day, the money was drawn from the bank, but it was not disbursed because it had come back. This complaint which was given, it had come back to the unit, and that money was not disbursed. It was again to the government treasury. A case is sought to be made out that there was a court of inquiry. There were some latches in the court of inquiry. These,
You're concluding your arguments today, or at least you are proceeding to complete your arguments. Yes.
actually, it won't take much long.
How much time? Half an hour, 40 minutes at least, if not an hour. So all the other counsel, I think we are good for the day with this matter. Because it will take an hour and then there will be some reply. So others may, if you want any dates, you can give it to the court master, we will furnish. Yes.
Now, when the report of the complaint came back to the unit, already the payment was initiated, it went to the bank, money was drawn, but since it had come back, this particular complaint had come back to the unit, money was not disbursed, it was put in the government treasury. Now,
There appears to be a complaint lodged by one of the petitioners that
no, not one of the petitioners, somebody else. It's not the petitioner. He shot up a letter. He shot up a letter to the head of the executive. Now, a case is sought to be made out that there was a court of inquiry and he was not given an opportunity. Some army officers were not called for as witnesses, and therefore, based on the court of inquiry, the memorandum of charges could not have been prepared as such because there were some latches in the court of inquiry. In this regard, I would just place before the lordship of
decisions will happen.
no, just to differentiate that he will not come into the court of inquiry. And if there is a court of inquiry, if he would have been a regular army personnel, that would have concluded in a court-martial proceeding.
Then to do what? You are arguing in 19, is it?
19.
19. Yes.
The case of Lordship Muhammad Ansari.
Let us see the court of inquiry findings. Where are they?
They are not annexed to the petition, Lordship. In any case, Lordship, that would not make any difference because he has to be proceeded under the CCSCCA. Being a civilian,
It's all right, but if he's a civilian, then why have a court of inquiry in the first
Lordship,
place?
court of inquiry is nothing
Uh,
but a fact-finding committee which has found something,
But
and
you
now
recommended departmental proceeding on the basis
Yes.
of which proceeding.
Now, in a departmental proceeding, what will happen is that whatever materials are there will be put forth to him. He has got a right to rebut them. He has got a right to examine the witnesses, and he has also got a right to bring his own witnesses there. In the case of Lordship Muhammad Ansari versus Union of India, I'll give a copy, Lordship.
They are under BRO, right?
They are under BR. They are, for some reasons, they are both under the Army Act. They would be governed by the provisions of the Army Act. In certain other spheres, they would be governed by the CCSCC. Now, that judgment, Lordship, of Muhammad Ansari versus Union of India, in paragraph 30, that is explained. Very.
1 minute. Yes.
First paragraph 30 of that page 12.
There are 30.
30. In view of the statutory framework, it is demonstrable that the 1950 Act and the Army Rules 1954 have been applied to civilian personnel of the GREF, that is have been applied to the civilian personnel of the GREF only for the purpose of discipline. The reasons are obvious. The GREF is a force raised and maintained under the authority of the central government, and its units are set up on the lines of the Indian Army. It works with and under close coordination with the regular army in border areas, facilitates the Indian Army to carry out its operational role, etc. Hence, it has been felt appropriate that the 1950 Act should be made applicable to a force raised and maintained by the central government.
Just a minute. Yes.
Hence, it has been felt appropriate that the 1950 Act should be made applicable to a force raised and maintained by the central government as considered necessary in the interest of discipline. The issue can be perceived from a different perspective. The GREF personnel are subjected by legislative scheme to dual disciplinary control, and such an arrangement is permissible as has been held in R. Vishwan. When the offence is such that the provision of the 1950 Act as extended to GREF apply for the purpose of discipline will be open to the competent disciplinary authority under 1950 Act to proceed against the delinquent under its provisions, and if found guilty, award appropriate punishment. In this context, we may give an example. If an offence is committed in relation to an enemy, Worship will kindly mark. Nice. If an offence is committed in relation to an enemy, offences on active service, mutiny, desertion, disobedience, etc., considering the nature and gravity of the offence, it may warrant severe action against the delinquent by way of trial by a court-martial. In other disciplinary cases, the competent authority may decide to proceed under the CCA rules 1965, in which the maximum permissible punishment is only dismissal from service. Now, here is the case where we propose, it's not where we propose, we have already issued a disciplinary proceeding under the CCS rules. And the petitioners herein have already submitted their written statement. That means they have subjected themselves to the provisions of the CCS rules and they are willing to participate in the disciplinary proceedings. They have already submitted their written statement, and after submission of written statement, they come and challenge the Lordship charge memo. So therefore, Lordship, once there is a disciplinary proceeding, whatever material is there will be put forth to them. It is another matter whether they will be exonerated in the disciplinary proceeding or they will be levied some penalty. But whatever materials are put forward in the disciplinary proceeding, only that they will answer. Because Lordship will kindly appreciate, on a court of inquiry, the disciplinary authority cannot impose a penalty. The penalty will be imposed only when there is a proper disciplinary proceeding. And he has all materials, he has the right to cross-examine the witnesses. He can also bring in his own witnesses to support his case. Therefore, there is a distinction between a court of inquiry. A court of inquiry, yes, if it results in a court-martial, whatever is there in the court of inquiry, that might be material. But here we are in a disciplinary proceeding. Therefore, what has happened in the court of inquiry, we are not imposing any penalty on you on the basis of the court of inquiry. We are framing charges, yes, we are framing charges, we are giving you all the materials, you answer that. Might be exonerated, you may not be involved at all. But can you now come and say that the charge memo is wrong? Disciplinary proceedings starts with the issuance of a charge memo. Therefore, there is a distinction between what is being sought to made out 180 of the Army Act and the current disciplinary proceedings. Now that has been very well answered. Yes,
Substantial period.
we have got some materials we have put forward.
This process of initiating the DP, ordinarily, find anything involved, you initiate a DP. But if you are not initiating the DP within a reasonable period of time, then there are judgments to where the court deprecates such practice.
Lordship, had it been a case,
Here is the key, which they are projecting.
delay,
There's a delay.
delay.
Now, which may appear that this delay initially occurred because very proceeding and they recommend.
Now, there was again an advice sought from the CVC. And the CVC had given an advice that major penalty proceeding should be initiated. Immediately after that, the BP has been started. Now, I would take your lordship to another judgment, which your lordship will. Another case of Aman. Just to bring a distinction between that army rules and the CCS, my friend was referring to a judgment and vehemently arguing. He was on Sanjay Jethi, 2014 3 SLR 38. Sanjay Jethi was a case where the appellants, all of them were from they were of the regular army. Therefore, the court of inquiry would have some significance. And that has been distinguished in a case which I have annexed as a annexure at page 119 in the WPC 482 of 24. Oh, it has been renumbered as 4864. This was 482 80. Aman Kumar. That has been renumbered. I'm sorry. That has been renumbered. Now,
Distinguished where?
in a judgment of in a Delhi High Court judgment, which I have annexed at page 119, annexure 4, in the last case. There also a reliance, if I may take your lordship to page 120 for a moment.
WPC 19.
No, in the last item,
Aman Kumar.
Aman. Interestingly,
One 22 of
of
your affidavit.
of my it starts at page 119, and I'm taking your lordship to page 120. That's
Sorry, this affidavit is filed by who?
affidavit in opposition filed by respondent 1, 2, 3, 4, and 5. The first item also I'm told.
84.
In the first item.
Don't say first item, second item, tell us the number of the name.
Randhir Kumar.
Randhir Kumar.
Page 84.
Yeah, in WPC 19 it is not there.
19 it is. Page 84. The judgment. And I'm taking your lordship to paragraph 5 of the judgment. That is internal page 4. What was the contention, lordship? Will kindly note. This Jyoti Singh, learned senior counsel appearing for the petitioner, would make two submissions. The first being that the respondents having subjected the petitioner to rule 180, similar as my friend of the Army rules 1954, during the court of inquiry could not have denied the petitioner the relevant documents and the right of cross-examination in violation of the statutory rules. principles of natural justice and the law laid down by the Supreme Court in this regard, she would also state that the proposed charge sheet sought to be issued by the respondents would be for deficiencies pertaining to the year 2008-9, and the same cannot be issued after an inordinate delay of about 7 years. In support, she also relies on this decision. Now, if I may take your lordship to internal page 21 of the judgment, that would be referring to paragraph 15. The page number is below, lordship. I may read, lordship. In Major General Rakesh Kumar Rumba, this court has taken a similar view that Rule 180 of the Army
Page 15, 1-5.
21. 10, that would be running page 10. Paragraph 15. Major General Rakesh Kumar Rumba, this court has taken a similar view that Rule 180 of the Army rules is required to be followed as is envisaged. Full opportunity to be should have been to a person whose character of military reputation is likely to be affected in the inquiry. But one aspect which differentiates all the aforesaid cases with the case in hand is that the officers in the aforesaid three cases, Lieutenant General Surendra Kumar Sahani, Major General Rakesh Kumba, and Sanjay Jethi, all officers against whom further action based on conclusion of COI was to be taken under the Army rules by recording summary of evidence general court martial. Whereas in the case at hand, the proceedings have to be initiated under the CCA rules. There is no provision akin to court of inquiry under the CCA rules 1965. In other words, the petitioner could have straightway been charge sheeted for misconduct. As stated by the learned ASG, that all the documents which shall be relied upon by the respondents during the inquiry shall be supplied to the petitioner. Take that statement on record. Now, here is a case where the charge memo has already been issued. Now, once a disciplinary proceeding starts, your lordship very well knows, the authority cannot go beyond what is there in the statement of allegations, the list of witnesses and the list of documents. If my learned friend is aggrieved by anything, he can definitely put forward, and if he has got a case in his favor, he can prove it by producing his own witnesses and by his cross-examination. Now the next paragraph. So far as the plea of Ms. Jyoti Singh, General Counsel, that the proposed initiation of department disciplinary proceeding for transaction taken in the year 2008-9 shall be hit by delay is concerned, law in that regard is well settled. She argued that the respondent should have some explanation to give for the delay that has occurred. The petitioner shall be at liberty to take this plea of delay in reply to the charge sheet issue. He can very well take it up. Now, for that reason, the charge sheet cannot be bad. I'll take your lordship to another decision of the Honorable Supreme Court in lordship Union of India versus Kutti Setti Satyanarayana.
Citation.
Citation is lordship of 2006 12 SCC 28. SCC 28. I'll be referring to paragraph. Lordship, I have given enough match with your Lordship's SCC.
No, we have your copy also.
Yes, Lordship. I'm taking the Lordship to paragraph 13 and 14. Fine. So far as Lordship, the challenge to a charge memo is concerned, well settled by a series of decisions of this court that ordinarily no writ lies against the charge sheet or charge or show cause notice by the executive engineer we have so and so. And these are the cases. The next paragraph. The reason why ordinarily a writ petition should not be entertained against a mere show cause notice or charge sheet is that at that stage the writ petition may be held to be premature. A mere charge sheet or show cause notice does not give rise to any cause of action because it does not amount to an adverse order which affects the rights of any party unless the same has been issued by a person having no jurisdiction to do so. That is not the case here. It is quite possible that after considering the reply to the show cause notice or after holding an inquiry, the authority concerned may drop the proceedings and or hold that the charges are not established. It is well settled that a writ lies when some right of any party is infringed. A mere show cause notice or a charge sheet does not infringe the right of anyone. It is only when a final order imposing some penal punishment or otherwise adversely affecting a party is passed that the said party can be said to have any grievance. And similarly, Lordship, similar proposition has been laid down in 2012 11 SCC 565. My printout, Lordship, it is paragraph 11, 12, and 13. If I may read, Lordship. 11. Ordinarily, a writ application does not lie against the charge sheet or show cause notice for the reason that it does not give rise to any cause of action. It does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction competence to do so. A writ lies when some right of a party is infringed. In fact, charge sheet does not infringe the right of a party. It is only when a final order imposing punishment or otherwise adversely affecting a party is passed, it may have a grievance and cause of action. Thus, a charge sheet or a show cause notice in a disciplinary proceeding should not ordinarily be quashed by the court. And these are the judgments. Paragraph 12. In state of Odisha versus Sangram Keshari, this court held that normally a charge sheet is not quashed prior to conclusion of the inquiry on the ground that the facts stated in the charge sheet are erroneous. for the reason that correctness or truth of the charge is the function of the disciplinary authority. Now, what he is claiming is these charges are incorrect. They are incorrect, or disciplinary proceeding will fall. Next paragraph, Lordship. Thus, the law on the issue can be summarized to the effect that charge sheet cannot generally be a subject matter of challenge, as it does not adversely affect the right of the delinquent unless it is established that the same has been issued by an authority not competent to initiate the disciplinary proceedings. Neither the disciplinary proceedings nor the charge sheet can be quashed at an initial stage, as it would be premature to deal with the issues. Proceedings are not liable to be quashed on the grounds that proceedings have been initiated at a belated stage or could not be concluded in a reasonable period unless the delay creates a prejudice to the delinquent employee. Gravity of alleged misconduct is a relevant factor to be taken into consideration while questioning the proceedings. Now, here is a case where we have come to know that there is a complaint given by an employee of that very institution. And when the complaint is referred back to that unit, immediately on receipt of that, you have withdrawn the money, and it is you who have initiated the bills. It is you who have initiated the bills, you have got it passed all through. Now you have also drawn the money, and as soon as the complaint is sent back, on the very next day, you do not disburse the money and you say, I'm so clean. Admittedly, Lordship, there are two sets of persons having the same Aadhaar cards and other particulars could not have been working at the same time in two separate units. Now, the petitioner's claim is the photographs do not match. Now, if the photographs do not match, it may be another aspect of the matter. That is a defense for you which you can take up. But the names match, the card numbers match. Therefore, Lordship, in my humble submission, this is a case where your Lordship will not interfere because it's a case, this is a lone case. There might be so many other cases. So, in my humble submission, Lordship, this writ petition at this stage has no legs to stand upon. There are materials in the charge sheet which he can very well suppose while he's filing his reply, he has already filed his reply, and post filing his reply, how can he come back and challenge the same? And interestingly, what has happened here is, Lordship, first case he got a stay, second case he did not get a stay, therefore he filed a petition in Tanagar, and it has been transferred here.
First piece, right here,
Yeah,
principal seat.
yes.
Then?
He showed that first case in Itanagar. He got a stay. He did not show the second case where he did not get a stay. There is another small case, Lordship, that is 1995 Supply 1 FCC 180. That is Union of India and another versus
95 supply.
Supply 1 FCC 180. Union of India versus Ashok Kakkar, AACKER.
One minute.
Plus,
Just 1 minute.
1995 Supply 1. And another is Ashok Kakkar. I'll be on paragraph 4. It's a very short one. I'll give a copy of this.
1995.
19.
Supply.
Supply 1. But let me read from paragraph 3
Yes.
of this. I'll read from paragraph 3 of this. To be clear. So and so learned counsel for the respondent does not support the tribunal's order for the reasons given therein in view of the decisions of this court in so and so. However, Sri Ramaswamy contended that the respondent has raised several other grounds before the tribunal for quashing the charge sheet issued to the respondent, which have not been considered by the tribunal in view of the fact that the tribunal quashed the charge sheet on the only ground given therein. On this basis, Sri Ramaswamy submitted that it would be appropriate to remit the matter to the tribunal for fresh decision on other points urged on behalf of the respondent applicant before the tribunal. Sri Ramaswamy strenuously urged that the basis on which the charge sheet has been issued to the respondent is not available for initiating the disciplinary proceeding. Inasmuch as the matter on the basis of those facts had earlier been closed by the department after full examination, submits that for this reason initiation of disciplinary inquiry on that basis is no longer permissible. Admittedly, the respondent has not yet submitted his reply to the charge sheet, and the respondent rushed to the Central Administrative Tribunal merely on the information that a charge sheet to this effect will be issued to him. The tribunal entertained the respondent's application at that premature stage and quashed the charge sheet issued during the pendency of the matter before the tribunal on the ground, which even the learned counsel for the respondent made no attempt to support. The respondent has full opportunity to reply to the charge sheet and to raise all points available to him, including those which are now urged on his behalf by the learned counsel for the respondent. In our opinion, this was not a stage at which the tribunal ought to have entertained such an application for quashing of the charge sheet, and the appropriate course for the respondent to adopt is to file his reply to the charge sheet and invite the decision of the disciplinary authority thereon. This being the stage at which the respondent had rushed to the tribunal with concern, there was a case where even before he had come to the court. Now, we are in a stage where the charge sheet has been issued and he has also filed his reply. And just because of the pendency of these cases now, the proceeding has not gone further. If he has got any ground option, I'm yet again making my submission option. If a proceeding is there against him where the materials are not there in the charge sheet, where listed documents are not produced, unlisted documents are produced, or some other witness is sought to be examined, which are not listed witnesses, he has the opportunity. At this moment, we have not even made up our mind whether we should impose a penalty or not. But is he going to give us an opportunity of determining whether we should impose a penalty or not? That would be solely our discretion after the proceedings have concluded. Now it is too premature a stage to come and say that the charge sheet, the charges are not made out. Yes, if the charges are not made out, the proceedings will be dropped. Why are you so apprehensive of that? Now, as it is, we have found that is a statement given by me in my affidavit in opposition that he was the person who had initiated the process. Therefore, bona fide, there is a charge. And my humble submission before your lordship of this lordship will not interfere with the proceedings at this stage. If any penalty is imposed upon him, definitely. If it is imposed, he has the rules, he has the powers, he has a right, but not at this stage. It is left to the authority, come to a conclusion. It has been initiated. The DP starts from the issuance of the charge memo. It has been initiated, he has responded also. Now, whether your lordship will interfere with this. And the decisions which I have referred to lordship will substantiate my case. That's all.
Respectfully submit, my lord. I am before my lord on three issues. Only that my submission that instead of first issue, that is instead of holding preliminary investigation, they prefer to hold the court of inquiry. And when the moment the court of inquiry is held, then the mandates of the Army Rule 180 to be followed, and it is their amendment in the item number 42 that they have initiated the further proceedings with reference to the recommendation of the court of inquiry. My humble submission, my lord, is to see whether the court of inquiry. Second submission, my lord, that whether memorandum of charges, because I have because memorandum of charges is a stigma. It is a reputational damage, and it is settled, decided in the LK Advani versus state of VR versus LK Advani's case. That is on a different issue. Okay, my lord, I bow down. I bow. I bow. My lord, please, my second issue is that my memorandum of charges is vitiated for the reason as shown in the paragraph. I just already held up. And third issue, that I have been prejudiced because of inordinate delay of holding the inquiry starting from 20th November 2020 and ending of issue of memorandum on 24th August 2025. In the meantime, I have been prejudiced because of I have been subjected to the court of inquiry. My promotion has been affected. My non-functional upgradation has been affected. Now, and these are the three issues I have submitted. Now, I beg to address to the points my learned ASG has submitted before me. First, he has stated with reference to Muhammad Ansari's judgment, which is decided, read with the our vision judgment, that is a Constitution 9th bench judgment decided in 1973, my lord. And that judgment paragraph, I want to hand over that how the BRO personnel, they have categorically stated the Constitution bench, how the BRO personnel are subjected to the Army Act or Army rule, along with the CCA rule. And there is a SRO also. May I read the 4 on 3, page 4 on 3, my lord, for a moment? This is the constitutional bench order, and it is said that it is the integral part of the army. The rules obviously owe their genesis to section 21, and they impose restriction to the fundamental right of members of grade, journalism, engineer force, my lord. Since the Army Act 1950 and Army Rule 1954 are made applicable by virtue of SRO 329 and 330, which I have submitted to my lord, because there is an exception. I cannot be reduced to the rank. I cannot be dismissed from service under the Army Act because there is a bar given in the statutory routine order 329 and
No, with regard to this judgment, what do you want? What is the submission?
But that means I am subjected to the Army Act, Army Rule, vis-a-vis CCA rule, and thereby they can attract the court of inquiry with reference to 180. Now I beg to draw my lord's attention to the case of first case, item number 42, my lord. It is the counter affidavit, my lord. Page number. First, I say that there is a complaint, my lord. How they have addressed, my lord, the complaint.
You are referring to this
My
one?
lord, I am referring the counter affidavit of case that is of item number, my lord, 42.
4861.
4861, my lord. Counter affidavit of Union of India, my lord. My lord, first page 63. I draw my lord's attention to page 63.
63.
Yes, madam. Keeping in view the discrepancy brought out in the vigilance check, court of inquiry was ordered by headquarter DGBR convening order dated 24/11/20 and read with additional court of inquiry 12/7/22. So my lord may note the delay of additional court of inquiry. To find out the exact fact, lapse, irregularities, and identity of the officer responsible for the same. Involvement of officer including the petitioner or prima facie established in the court of inquiry, oblique preliminary inquiry. No, my lord, it is not. They did not hold any preliminary inquiry. And final recommendation or order of initiating disciplinary proceedings under Rule 14 against 12 officer of 55 RCC, including both the petitioner under Rule 16 against one official, it was issued by order dated so and so. So, based on the recommendation, they have initiated the disciplinary proceedings. Now, I draw my lord's attention to the to page 70, down below, my lord. I read, my lord.
Yes.
The recommendation for initiating disciplinary proceedings have been issued only after following due procedure as per outcome of vigilance check carried out by the department and outcome of the court of inquiry. It is their apartment, my lord.
Page
My
number? Page number?
Page number 70, my lord.
of their abandonment, the counter affidavit. My lord, then this, I draw my lord's attention to now page 766 of the counter affidavit. My lord, learned AG has stated, yes, I have got the right. Placed all the to place the witnesses of my choice at the high courts of the inquiry, my lord. My lord, at the during the course of the disciplinary process. Yes, my lord. I correct myself, my lord. So, my lord, I draw my lord's attention to the to my writ petition.
No, you are referring to 76.
Page 76, wherein they say, my lord, I read down below, my lord. Just one thing. As far as Captain Vishal Mahan, Army Medical Corps of Headquarters 76 PRTF is concerned, he may be included as defense witness by petitioner in the disciplinary proceedings. When I raised the bogey that yes, we have done, they have not been cross-examined during the course of the court of inquiry to cover up the issue. Now they say, Captain Vishal Mohan, you bring it during the course of the normal departmental inquiry. Now I give in my writ petition, my lord. Now I draw my lord's attention whether Captain Vishal Mohan has been shown as a witness in the prosecutorial witness in the memorandum of charges. If this is so, can a prosecution witness be a defense witness?
Lordship, he has the right to cross-examine.
Yes, sir, let me finish, sir. I'll just counter, then I'll sit down. Let me. My lord,
Yes.
I draw my lord's attention to page 35 of my writ petition, that is of 42, item number 42, writ petition number 4861, my lord. 4861, annexure list of witnesses they have given in page 35, my lord.
Yes.
And this is number 6 is Captain Vishal Mohan as a witness. Page number 35.
Right.
Captain Vishal Mohan is the witness, my lord. And
Yes.
And surprisingly, my lord, all the charge official has been named as a witness. So these witnesses are inconsistent. What are the terms of reference? As the learned AG has stated, preliminary investigation of the court of inquiry differs, because there the question of the maids, the role of the other officers were questioned in the terms of reference, and they have framed the memo of charges of different phenomena, my lord. So, my lord, here, Captain Vishal Mohan, being a prosecution witness in number 6, can he be a defense witness as per their requirement? This is my submission, my lord. Now, my lord, they have quoted the judgment of that Honorable Justice Rao of Delhi High Court, my lord. The ratio of judgment is not applicable in this. Why it is not applicable? I read from the first paragraph. The commissioner is number 2 in the Delhi High Court, my lord. The challenge is the repetition is the communication dated. May I read page 84, my lord? I beg pardon.
The reference is now.
Not necessary. Yeah, I apologize. page number 20, page number 84, my. My lord, the issue here is that in this case, the petitioner went to the Delhi High Court for the delay in issuing memorandum of charge. Before that, he has attended the court of inquiry, my lord. And as the various reference, I beg to draw my lord's attention. The challenge in the writ petition is to the communication dated June 16 from senior administrative order on behalf of Director General Border Roads to the Chief Engineer Gongma, where the Chief Engineer was directed to forward charge sheet along with the list of documents with regard to certain officer, including the petitioner hearing, my lord. If my lord go through the have a look on the judgment, the petitioner has participated in the court of inquiry twice, one court of inquiry and then additional court of inquiry, and he came to the court apprehending that there is a delay in issuing the charge sheet, my lord. Why? This that is the reason. That is the reason the honorable judge has stated in 14, the court on the issue whether Rule 180 is married, page 103, my lord. This court on the issue whether Rule 180 is mandatory or directory had referred to various judgments of Supreme Court and High Court and hailed that view taken by all the High Court and Supreme Court is that whenever reputation and character of a person subject to the act is likely to be affected, the requirement of law in compliance to Rule 180 and to that extent to the provision of Rule 180 as mandatory. Wherever there is a lapse or default prejudicially affecting the right or protection given to a person in terms of the said rule, the proceedings should be vitiated. Of course, conducting a court of inquiry is not a sine qua non to commencement of any proceeding under Rule 22 or convening a court martial. Even for court martial, it is stated, I bow down and submit, my lord, that it is not a mandatory requirement. But once somebody choose to hold the court of inquiry, the mandates of the court of inquiry to be followed. And finally, my lord, he has stated in the last paragraph, yes, in so far the plea of Mrs. Jyoti Singh, my lord, learned senior counsel, that the proposed initiation of disciplinary proceeding for transaction taken in the year 2008 and 9, I am reading from 105, last paragraph, shall be hit by delays concerned. Law in this regard is well stated. She argued that the respondent should have some expression to give the delay that has occurred. So, to sum up, my lord, here, charge sheet has not been issued. She came to the court of law for furtherance of issuance of charge sheet, and the court observed in the entire judgment the mandates of the 180 has to be followed, and this individual participated in both the court of inquiry. Now, my lord,
But in the judgment of Sanjay Jethi,
my lord, if my lord permits, Justice Commissioner Rao has passed in another judgment on this issue, which I have annexed with my rejoinder affidavit in item number 44, my lord. I want to read. So my lord will find the difference. Same judge has passed the order, my lord.
so right, what we want to say, first, during the opening arguments, you relied on Sanjay Jethi
Yes, my lord.
to submit that the rigors of court of inquiry has to be scrupulously followed.
Yes, yes, my lord.
Now, which the learned DSGI submits that this judgment is only has to be read in the context of the officers who are uniformed officers.
No, my lord. I am also uniform people. That's why, my lord.
You are an uniformed officer,
Yes, my lord.
not a civilian.
No, my lord.
Then
Army Act is applicable.
Lordship will grant me the liberty will court martial.
Just
That-
let me
that is
submit, sir, I'll just sit down. My lord, I beg to submit.
No, but you said you are a civilian employee.
My lord, I am subjected to the Army Act, putting on the,
Mr. Counsel, don't oscillate in your arguments. Your arguments, we may accept, we may
my
reject.
lord, I, with due
remember-
respect, I
remember distinctly.
yes,
that
my
it
lord,
is
I
your-
still reiterate this thing, my
that
lord.
you are a
What I
civilian.
reiterate, I am a civilian. My terms of appointment has been given in the counter, my lord.
No, but then
I
why
am
did you, why did
subjected,
you say that you are a uniformed officer?
my lord.
You are not a uniformed officer, as understood ordinarily.
Army Act is applicable. to
Army
me.
Act is applicable is one thing.
Yes, my
Army
lord.
Act may be applicable to civilian people also.
Yes,
Because
my lord.
Army Act is applicable, if you see the definition, it is applicable to all who are under the army or are working with the army for a given purpose of time. So Army Act could be applicable. It's one
Yes, my
thing.
lord. My lord, here in the border rules, army personnel are deputed as per the manning list.
No, so therefore, see, if you say that Army Act is applicable, therefore, court of inquiry which is conducted has to meet the rigors. Then the question is, the corollary question would be, if Army Act is strictly applicable,
Yes, my lord.
would there be a reference to CCS, CCA rules for disciplinary proceedings? You have to follow the
My
mandate
lord,
of the army.
my lord, that choice, after conclusion of the preliminary court of inquiry,
That's right.
the choice has been given to switch over. It is
So-
up to them whether they can go for CCA rule or Army Act. Why, my lord? I have submitted to my lord statutory routine order 329. My lord, if I am to be dismissed, if I am to be reduced in rank, there is a bar given in the statutory routine order. my lord.
Where is the routine order?
I have submitted to my lord along with the R vision order. Just now I have submitted.
See, there are too many papers here.
I
You
have
have
just
to
now
collate
submitted.
all these papers
I can
and
submit
submit as a
Sir,
paper if you want.
a sort of statutory routine order 329, 330 my lord. One page.
One page, but ask you to make a compilation of the documents and the judgments that you want to submit. That we don't lose track of, we have to refer
Yeah,
to all your
I apologize. I do.
apology required. You just ask them to submit it.
My lord, I have just submitted along with the R vision order.
Now, I've got it. It's
329 and 330.
330, yeah.
So these are the sections, my lord, which bar the department for proceeding against me. They cannot initiate action under those sections of the Army Act vis-a-vis Army rule. That's why, my lord, the choice has been given to switch over to the CCC. Because as for example, my lord, I cannot be reduced in rank, I cannot be dismissed, I cannot be stripped of my badges as per the relevant provision of the Army Act. The exception has been put in the statutory routine order 329 and well, now in this my lord, this since I have read the judgment of Honorable Justice Rao, my lord, what learned age has read, and I draw my lord's attention to my joined affidavit, my lord, in item number, my lord, that is of 44, my lord. Item number 44, my lord. Rejoined affidavit. Page 216, my lord. Page, I draw my lord's attention to, this is the same judge, my lord, passed an order, my lord, Colonel Sandeep Sharma. Versus Union of India. My lord, I draw my lord's attention for only one paragraph. 249. Item 44, my rejoinder effect. Page 249.
We are yet to get.
Page 2491, my
Yes.
lord. Para 103.
103.
May I read, my lord?
Yes.
In fact, we may note that it is the policy of the respondent that non-compliance of 180 not only vitiate the court of inquiry, but also vitiate the subsequent administrative action on the basis of such court of inquiry. The relevant paragraph of the said policy dated December 15, 2000 is reproduced as under. This is the army policy, my lord. The learned judge has quoted this policy. A careful examination of the matter in entirety clearly show that violation of regulation of army, RA, my lord, 518 and non-compliance of army rule 180 are two distinct issues. Violation of para 518 would not mean non-compliance of AR 180 and would not vitiate the court of inquiry proceeding. And subsequent action taken on the basis of such court of inquiry, it is only the non-compliance of Army Rule 180 which would vitiate the court of inquiry proceedings, and particularly the subsequent administrative action. The army, he has quoted, my lord, this is the relevant para from the army manual, my lord. So the subsequent administrative action which the Union of India has committed in the counter affidavit, that yes, memorandum of charges arose because of the recommendation of the court of inquiry.
If I may just.
That,
Your
sir, you
Lordship,
can note it down and
no,
let
I
me.
have noted it.
I
It's
just
no use just wasting
I'll
the time.
lose the sequence, my lord.
Worship will just see page 217. That is
Oh.
on the same. That is the case of a uniform person. 217 makes it very clear. Even the title, Colonel Sandeep Sharma.
My lord, I beg to interfere that Army Act is applicable, Army Rule is applicable, 180 is applicable. That's why they invoke the court of inquiry. Now, because of that reason, I just draw my lord's attention to the lord's attention to the
So that's what we are asking you, that for uniformed officers, okay, but
my lord, see, just for a moment, my lord, see how they have convened the court of inquiry. It will give a lot of clarification to my lord. I'll be very grateful to my lord.
no. If it is a case that court of inquiry being conducted in your case, as per the mandate of the Army Act, Army rules, the rigors will have to be maintained.
I bow down, my lord.
Then the question of having the option of sending you disciplinary proceedings. Number one presupposes that you are not an uniformed officer. Otherwise, they would have gone for court martial, etc., summary court.
A summary of evidence they could have conducted,
They could have.
but they
No.
did not.
They did not. Now, it is not your case that you are not subjected to disciplinary proceedings. That is not your case. It is not your case that reference to proceedings under CCA's rule is not correct because you are governed under the Army Act.
No, that is not
That's
my,
not your argument.
that is not my submission.
Absolutely, we understand. So therefore, your argument is that this court of inquiry which has been done and which recommended the disciplinary proceeding will have to be understood to be in the form of a preliminary inquiry.
No, my. They could have hold the preliminary, my lord, for to clarify my lord's doubt.
No.
May I?
But I want to sort
Yeah,
of,
yes, my lord.
sort
Yes,
of
my lord.
comprehend your arguments.
No, no,
Is number one, your case is that this court of inquiry and the review court of inquiry, etc., took some time. And finally, they recommended disciplinary proceeding. As a result, substantial period of time has elapsed from the date when the incident is alleged, as far as you are concerned. Therefore, you are now prejudiced by the fact that this delayed proceeding have, besides being prejudicial to your
Promotions, which is the prayer.
promotions and service benefits,
I prayed.
is totally against the procedure prescribed under the army rules, because court of inquiry according to as per the
No, my
army.
lord, that is
Now,
the three
now,
aspects.
now the question is, even assuming we'll agree that all right, the procedure prescribed under court of inquiry is strictly not followed by the authorities. Fact is that you are recommended to the department proceeding under CCA. Now,
Yes, ma'am.
CCA rules. The proceedings again have not proceeded because of the interim orders passed by the court. Now, you have the complete forum available before you. But from these allegations that they are not supported by
My lord, what happens if the memorandum of charges is vitiated? What is the law laid down in?
if it is vitiated, the vitiation has to be. It's on a very limited ground. Number one, jurisdiction that the person who has issued the issue was not authorized.
No, not that, my lord.
Not that.
It is of uncertainties. It is lack of
That-
record.
So therefore,
I have
therefore-
spelled out in para 10, my lord.
Therefore, alternative argument is that the charges are not definite.
Charges are indefinite, my lord. Charges, even name spelling is mistake.
Essentially, you're questioning the department of proceeding on the ground of charges not being definite.
Yes, I have a right to come before my lord
Certainly,
when I am aggrieved on the charges.
We are not closing doors on you there. We are asking you, why are you repeatedly referring to the court of inquiry? Say that, see, it is contrary argument. On one hand, you say you governed by the Army Act. If you are, then your argument should be that this particular proceeding itself is beyond jurisdiction because you are amenable to Army Act and Army rules. Number one. Number two, if you say no, well, control is there, so they have recommended before the authority. If that be the case, then the question of saying that the court of inquiry proceedings are not as per the rules, that option may not be a ground to interfere with the proceeding. Leaving aside your argument that the charges are indefinite. This is an area where we can certainly look into.
Why not? It is the admission of, why not just clarify my lord's doubt. In writ petition 42, page 14, for page 15, page 14, my lord.
Yes.
Just I just want to put some material for my lord's consideration. That is a convening order of the court. Page 40.
Of which writ petition?
Writ petition number 42. My lord.
Writ 6.
40. My lord, in page 20, my lord, is say para 8, my lord.
Para
8, my lord. Page 20, next page, my lord. This is a convening order dated.
No, you are referring to page 42.
my lord, this is my lord, page 20, page 20, my lord, page 19 and 20.
19 and
20, item number 42. Item number 40.
Item 40. Don't say item, you give
I
us the
beg
name
my-
because. you don't know
I
which item
apologize.
we are handling. Right. 19 is annexure 1.
Yes, ma'am. They have convened the court of inquiry. A court of inquiry composed as under will assemble at a place, date, time, fix, to investigate and call evidence as may be applicable with matters set out in terms of reference. Now they have set the terms of reference. The methodology adopted in CPL's RCC, including the role of task force and mates, to identify CPL having identical name, father's name, verify the genuineness of their related documents, Aadhaar card, my lord, which is the basis of recruitment, to ascertain the actual deployment of CPLs vis-a-vis the master role in the way of physical check of CPLs and labor sanction master role, to ascertain whether payment of wages is being made to CPL to their respective individual bank accounts or otherwise in case the same are being paid to their own bank account, scrutiny wages credited in their accounts. In case of payment of wages of CPLs are being made to other means other than the own bank account, reason for deviation from the latent policy issued by headquarter DGPR audit authority. In case of instances of false mastering come to light, if any incurred, the state be brought out and official responsible for the same be identified and other irregularities, compliance with procedural lapse of the objections by the court of inquiry, requiring deployment, payment of wages to CPL. The court will investigate the allegation leveled by, as my learned AG says, that is the complaint, my lord. So, by Tinku Thakur, my lord, then then in para 6, that is vital, my lord. This is the terms of reference, my lord. Para 6, attention of the presiding of the officer and members is drawn to the following provision of Army Act, Army 180. The court will invoke provision of the same wherever applicable. Army rules 179, 180, 182, paras 508, 519 of regulation of the army. What I have read from the Honorable Justice Rao's order, I have quoted that regulation as is quoted. And some other, my lord, the proceeding duly, that is on 24 November 20. Because cause of action happened 25 July to 20th, 20th August, August of 2020 COVID. And finally, my lord, the delay part, as the delay part is concerned, then additional court of inquiry held, my lord, with the same VK Goel as a Cornell, on 12 July 22. After 20, it is in 22, they held the court of inquiry, my lord, additional
Now,
court of
this
inquiry.
inquiry, once held, certain notices are to be given. The persons who
Yes,
are to appear.
my
before
lord,
the
they
court of
should be present throughout.
inquiry. Where are the notices? Here? Shown somewhere?
My lord, the proceedings are not given to the petitioner, finding not given to the petitioner. So on the convening order we had. So my lord, this happened, my lord. Now, so this is the court of inquiry that happened. Now, this in an judgment from this case I also read, my lord. Now now the complaint part, my lord. My lord, when the casual paid and revered for 179 days, the master roll comes on 21st, and we next month 20. So Tinkuja made a complaint as learned AG stated on 18. When I have not reached the master roll, how Tinkuja came into the fore in complaining that there is business.
We are not going into the allegations, the correctness of the
Yes, my lord.
allegations.
Now, my lord,
We are examining the procedure.
my lord, I'll draw my lord's attention to the policy. Now, my lord, may I like to have a policy of the department, how they recruit these casual paid laborers. My lord, I draw my, this is the item number 44, my lord.
It's difficult for us to move from brief to brief like this. You take one brief and start arguing. Don't say item 40, item 40. This affidavit in item 40. That
My lord,
affidavit.
I'll finish with 44 only, my lord. I'll not bother, my lord.
Huh?
Aman Kumar. I'll not bother, my lord. This is the my this petition I'll concentrate. I'll finish
Right.
it in 10 minutes.
No, you can do it. What we are saying is that you
Yes,
have to-
my lord. I
you have to-
apologize, my
You
lord.
have to give us a paper
I
who
do
can say
apologize,
that these papers are in this petition or that petition.
Yes, my lord. I bow down, my lord.
Yes, yes, yes.
I'm
Page
so
number?
sorry, my lord.
Page number.
Page number, my lord, that is annexure 1, my lord. Page 23, my lord. Page 23. That is of my writ petition.
General guidelines.
Item number 44, Aman Kumar.
General guidelines.
General guidelines, my lord. I read from the next page, page 24, my lord. Salient part I will read on. My lord, this is here, it is stated biodata, medical examination.
Is it relevant?
My lord, yes, my lord.
Why?
Why it is relevant, my lord? Each CPL who are bought or working 18 CPL, I mean 18 CPL, where the drought kept into, they were medically examined by Captain Vishal Mahan.
We are not on the merits. We are not on who's responsible, who's not responsible. You are challenging the departmental proceedings. You know that we are not an appellate authority. We
Yes.
are examining the departmental proceedings from the point of.
No, I am not challenging the departmental proceeding.
You are challenging. What are you
This,
challenging?
I am challenging the memorandum of charges, my
That's
lord.
right.
They have
Memo-
initiated.
Memo of charges.
Yes, my lord.
Memo of charges. You are
Yes.
not challenging the proceedings.
Because no, because I have a right to come before my lord with reference to the judgment which I have quoted, my lord, that that judgment.
You are only challenging the memo of charges.
I have challenging the three things, my lord. My lord, state of Punjab versus DK Kanda. 30th 11 2000 judgment, my lord. This judgment says, my lord, if memorandum of charges is vitiated, then further proceedings will be a farcic also. Well, the state of Punjab versus DK Khanna.
Therefore, there has to be a consequential prayer that because of these reasons, challenging the memo of charges.
I have paid accordingly, my
I
lord.
have not seen your prayer in this item.
Yes, my lord.
5-7.
Aman Kumar, I have paid, my lord. Every item I have paid accordingly, my lord.
You have paid
And
for setting aside
and yes, my lord.
the charges. All right.
Well, this I have cited that this just for a para 12 in the writ petition page 11. I have cited the details why the memorandum of charges is para 11. Para 12 page 11, my lord.
Right. We have understood you. Then close the hearing. Then.
Yes, my lord.
Reserve it for them.
So, my lord, my humble submission, the preliminary investigation, whatever they say of the court of inquiry, the terms of reference I have read before my lord is inconsistent. Is what is the contents of the memorandum of charges?
Mr. We close or you'd like to?
No, Lordship, whatever he is submitting, that is on another aspect of the matter. here on. Something is laid out. There is something in the
But
mind.
you have to, he is addressed, he is challenging it on the ground of vague, indefinite charges.
That cannot be.
But
Now,
you will have to reply to that. I don't think you have replied to that. Your reply was to the extent of whether they are governed by Army Act or not by Army Act, whether
Lordship will keep it on another day.
what we are asking you, if you want, we can
Yes,
keep
yes,
it. Otherwise,
I
we close
I
it.
will definitely address your
We have
lordship.
understood your.
Definitely address your lordship.
Tuesday, madam.
Tuesday, we are overloaded. You can try on 2nd, that is Thursday. 2nd of April. Subject to
7th of April, my lord.
second.
7th of April, my lord.
7th
Or my,
7th of April also. 7th April.
Tuesday it is difficult for my lord. This Tuesday it is, my
This
lord is
Tuesday.
overloaded.
We have some matters, we don't know, we can keep it, but we don't know whether we can
Let it
complete the matter.
7th of April.
7th of April, we can.
Problem. My lord, this, because, one, I just last but not least, because of the inordinate delay, I have been subject to double jeopardy, my lord. My
That-
promotion has been affected, they have admitted it.
That we have heard,
Deeply obliged. Please,
Heard. for the hearing, 7th of April.
Duplicate.